Your Honors, I am filing a memo for listing the matter at 2:30. The urgency is such that,
Possible.
Your Honor, the urgency
I'm
is
not
such.
sitting at 2:30 today.
Your Honor, today there's a JCB parked outside my property for demolition. Compromise has been entered into leaving me out, and FTP has also been disposed. I have filed for stay before the trial court. However, the matter has been posted for objections. They're coming to demolish my property today, Your Honors. I have photographs showing that they're in front of my property
When
at
was the order passed by the trial court?
4/8, Your Honor. I've applied for certified copies. It's rural court, Your Honors. I've procured the copies yesterday. I have the slips for the same.
At 1 o'clock.
Grateful.
Yes,
Lords,
follow it.
moving a matter for 2:30, my lords. The urgency is this, my lords. An injunction was granted in my favor, my lords, but the court with the concurrent charges, they refused to extend my interim order, which was operating against the defendant bank. On the contrary, my lords, the trial court also directs the bank to go ahead with the SARFAESI proceedings and to take over the possession of the property. Now there is an imminent threat of dispossession, my lords.
When was the order passed?
4th of August, my lords. Day before yesterday, and immediately we have filed, my lords.
1 o'clock.
Ladyship, the execution proceeding is pending. It's on 13th, Ladyship.
So,
Ladyship, we had filed a WP on previous order. It was stated that it would to be listed with the MFA. Meanwhile, they have filed an execution proceeding, and it's pending on the 13th, Ladyship.
13th is when? 13th is there is a lot of time. By the time it will be listed.
Ladyship, kindly on 10th or 11th.
When is it posted that MFA?
Not the MFA. MFA is supposed to be listed with this WP. The last order.
Can't be listed along with
That is fine, Ladyship.
When is it going to list?
It was supposed to be listed after 2 weeks. It's pending from February, Ladyship.
When did come? When that matter came up before this court?
February, Ladyship.
We'll see. Will you move a memo on that day? Yes.
One matter for window of the Lordships has heard the matter and passed an order demanding the matter to the trial court for consideration of the IAs. The issue, my lords, is that the plan.
What happened to that?
The IA has been dismissed. One IA has been dismissed. Other IA, the court has said that it falls out the scope of the suit. The urgency is.
When was the order passed?
Order, my lords, the order was passed on 1st of August. Yesterday, the certificate copy was released. I filed my WP.
What is the implication of the order now?
The application was for one was attachment before judgment, and other one was for the deposit of the money to the other defendants. I am the second creditor. The first creditor has sold the property, and now I have filed an attachment before judgment. The Lordships have heard the matter comprehensively and passed an order remanding the matter to the trial court. Now, the application, without even hearing me, has been disposed of.
What is the urgency I'm
The
saying?
urgency is that they may take the money today, my lords. The money from the bank, the defendant number 1, 2, 3 may take it from the defendant number 4. I am the plaintiff who was claiming the attachment before the trial court. Now they take the money, my lords, and the entire suit will become infructuous.
Why it will become infructuous?
Because one issue is
What is the suit for?
They are habitual defaulter.
What is the suit
recovery
for?
of money and this attachment of sale proceeds from
Attachment before judgment is dismissed. Your suit becomes infructious. I'm not able to understand.
The Lordships have comprehensively heard the matter.
I might have heard it, but it won't become infructious. Suit will not won't be infructious by dismissal of an IA.
If they take the money today, my lords,
No. You file it will come. Yes.
my lords, I filed it, my lords, kindly be taken up. to 13.
No.
My lords,
Not an urgency. 2:30.
Otherwise, they are
It's not.
habitual defaulter.
Let them-
Cases have been dismissed.
Least to serial number 3, Milords. There is some urgency, Milords, may be taken, but 2:30, Milords.
Today it is not possible. I've already given 3-4 matters. We'll make a mention on Monday. Yes, call the list.
Monday 2:30, Milords. Monday 2:30, Milords. Least to.
I have moved 3 times.
Already passed orders to withdraw all the other said suits. Senior counsel will engage in said matter. We already listed seal number 70, my lords, list 1. Kindly be taken up at 2:30. There's urgency in said matter. Revision bench has already passed
What is to be
orders.
done? What is to be done if I take it to
No, the revision bench already passed orders to withdraw everything, and arbitrator has been appointed. Senior counsel will engage in the said.
If you want to withdraw, I'll pass orders. Not to withdraw.
No, senior counsel has better instruction with respect to the same.
What senior counsel will do for withdrawal?
No, the 2:30.
I will not take up any matter 2:30, no urgency today. It will come on Monday.
Seal number 70 is already listed.
I said no. I'll
Lord,
not.
one matter for end of the list, my lordship. There is urgency, is the matter is this one.
Today, enough of the list.
My
I'm
lord.
not taking up any matter at
Lord,
2:30 because
commercial-
I'm raising at
My lord,
2:30.
Bescom connection, they are
Yes.
disconnecting, my lord. They have passed the order for
My lord,
disconnecting, my lord. It is a
this is
commercial
for
property.
listing on Monday, my lord.
My lord, it is commercial.
Listing on Monday, Monday you can
My lord, it is
mention.
commercial property,
Call
my
the
lord.
list.
It is already final order title has been confirmed in my
My lord,
favor by
I-
High
Lord,
Court.
my lord,
Three times, my lord, I
one
have
submission,
moved
my
on
lord.
3
Every
times.
day this.
After
Not
say-
for 2:30, my lord, not for 2:30, my lord.
If not 2:30, give a memo.
My lord, it is for connecting that matters. It is with regard to sub.
Thought you give the memo to the court officer. I'll pass order.
My lords,
May I actually request for Monday, my lord?
Memo is filed stating that the relief sought in the writ petition as the petitioner does not want to prosecute the matter. Memo is taken on record and dismissed as withdrawn.
my lords, request for adjournment, my lords.
Serial number 2.
I,
Yes, serial number
my
2.
lords.
Serial number 2.
Yes, serial number
Lords,
2.
this is the writ petition, your lordships, in which
The
the
counsel for
Bescom's
the
order
respondent.
you.
You argue the matter, what it is.
Please, my lords. Lords, as to the yesterday's aspect of what is the manifest error in the order. My lords, in 2021, a similar proceeding had been taking place. A provisional assessment order had been issued against me. I responded to those provisional assessment orders in writing. The proceedings dropped. No final order was passed in terms of section 126. Thereafter, 4 years later, a fresh proceeding is initiated against me. Similar, I make again same right back and object to the initiation of the proceedings and the back billing that they are intending to levy on me. I also highlight, look, in 2021, you'd already dropped these proceedings. Why is it's coming back up again? In the order, the officer says for administrative reasons, the 2021 proceedings did not result in an order. And I'm now merging that order and that proceeding into the current proceeding. My lords, the merger of two separate proceedings is the process that is adopted, which is unknown in law. There is no provision in either the conditions of supply or the Electricity Act that permits the assessing officer to merge two separate proceedings. My lords, by the lapse of those proceedings, earlier 2021 proceedings, I'm entitled to the benefit of that by operation of law, by not passing the final order within the
Come
timelines.
to that order. Come to.
My lords, impugned order is at page A, sorry, annexure A. Translation copy is at page number 82. The operative part of the order, your lordships will find at page 89.
Yes.
Lords, at the point number 3, which is the due to administrative reasons, no order could have been passed. Your lordships have point number 3, my lords, the bullet point number 3. Due to administrative reasons, no order could have been passed in the case registered in the year 2022. Therefore, the said case has been reviewed and proposed to be dismissed. Immediately thereafter, Lord's point number 5, bullet point, in the above background, since no order was passed in the earlier case and the complaint, the nature of the allegations and the issue involved are the same, the earlier case has been merged with the present proceedings, and the matter has been continued accordingly. And in the operative part, Lords, the bottom part, the present order is issued by merging the case relating to misuse of tariff registered against installation so-and-so with the present case. Lords, section 126 of the Electricity Act.
No.
Huh.
It says, therefore, the said case has been reviewed and proposed to be dismissed. Arrears were calculated only for 1 year.
Lords,
Fine. So, accordingly, arrears have been calculated for the period from May 2015 to September 2025, an amount of rupees, and the customer has been called upon to remit the said amount through the notice issued.
Please.
It's from which year to which year?
Lords, September 2015 to September 2025. April 2015 to November 2022 is done back billing.
What was the earlier order?
Lords, earlier order was an assessment for 1 year. The 4 lakh amount that your lordships will see in 2021.
Forget about that. Itself cannot be a ground. What about the other billing for the other years?
Sorry, ma'am?
Leaving away that year.
Yeah.
What about the other years? Why they cannot do it?
Lords, that is on the process. On the substantive ground, Lords, there is no misuse. So section clause 42.02.
Okay. According to you, you cannot go before the appellate authority and you can come before only this court.
Correct.
Showing this. So, leaving this also, still there is a cause of action for them.
No, my lords, under section 56, there is a limitation of 2 years. Look back period is of 2 years. They cannot now, after 10 years. I've been using HT2A and I've been paying tariff in HT2A since 1999. Now they can't look back in 10 years and seek to impose this back billing on me. There is a limitation under the Electricity Act, section 56, which states that in case of recovery of arrears, unless and until arrears are shown in the bill, you can't do it for a period behind 2 years. That's the provision, Milords, section 56, disconnection of supply, the Electricity Act. Milords, in addition, Milords, essentially misuse has to be found. This penalty has been imposed. 56. (56)(2), Milords. Notwithstanding anything contained in any other law for the time being enforced, no sum due from any consumer under this section shall be recoverable after the period of 2 years from the date when such sum became first due, unless such sum has been shown continuously as recoverable, as arrears of charges for electricity supplied, and the licensee shall not cut off the electricity supply. Because in 2021, when the proceedings lapsed, and for them to initiate from 2015 is illegal, Milords. They can't do that because I have been entitled to the benefit of the order from 2021 because the proceedings lapsed. They cannot go back before 2021 in any manner. For them to now merge these proceedings and say, no, I will go back to 2015, and from 2015 I will levy this fine.
Then what about 2020, 24, 25?
Milords, Milords, it's on the substantive issue of whether misuse has happened. This court has held in several cases that for 42, clause 42.02 of the conditions of supply to apply.
Then to look into all that.
Milords, we argued all of this before the assessing officer. He's not understood any of that. Irrespective, Milords, the substantive finding that I have misused is lacking. Your Lordships will see that in the inspection report.
That you will not question it. Every matter, that is what would be every observation of the authority, that will not give you a right of coming to this court by bypassing the right of appeal.
No, Milords. To exercise this jurisdiction under section 126, there has to be a finding of misuse. There has to be prejudicial use of electricity under clause.
What the appellate authority is?
Milords, that may be so,
Order of the
Milords.
primary authority.
Milords, this essentially is a misclassification matter, Milords. In the sense, it's not even a misuse matter. The contention of BESCOM is that HT2V should apply and HT2A, not HT2A. I'm a software industry. The KERC ultimately decides what tariff applies to who it applies. In the KERC tariff order, software companies are entitled to HT2A electricity tariff.
What will happen is, High Court, by entertaining all these red petitions, the entire exercise of the material and all not before the court. If it is before the authority will be able to appreciate it because they're well versed with the technical aspects.
Milords, the problem is this, Milords. When there is no finding of misuse by their own documents, the inspection report, the spot measure that happened, does not find any misuse on my part. It simply states that I didn't submit an ITBT certificate. Now, ITBT certificate is the Information Technology and the Biotechnology Ministry certificate. My case is that I don't need that. I don't need to submit that because my connection is taken from 1999. Their own circular says of 2006 says if your connection is before.
What I'm saying, appellate authority can't deal with it.
Milords, appellate authority cannot deal with this. In addition to Milords,
Why they can't understand it?
Milords, I have to now, the appellate authorities in MESCOM, Mangalore, for all appeals arising from BESCOM, 50% deposit I have to pay of the amount which has been calculated from 2015 to 2025.
What happens is there are also effective mechanisms for redressal of these kind of grievances. Why should we entertain all this?
Milords, because it's an entirely illegal order, Milords. Milords, can I submit a judgment of this court?
Judgment is not required.
Milords, in the sense, Milords, to demonstrate in a matter where similar misclassification.
Convince it with all what you say. After that, I'm asking you this question. Let's say that there is why can't that be clarified with the appellate authority?
Because if your lordships were to quash this order in entirety and direct the BESCOM to reassess
That
this
is what the
situation.
appellate authority has to do.
But there is a condition, I have to pay 50% deposit before that. And disconnection has already happened.
So every order of illegality has to come before the court
Plus,
because you
this
have
is
to
a
pay.
patently illegal order, Millards. Merger of two proceedings. There is no process for merger of two proceedings, which vitiates the entire process. They have not followed the
You pay
timeline.
some amount, we'll decide.
Millards?
You pay some amount, we'll decide. As far as 2 years is concerned, whether there is any procedural illegality or there, we will decide.
Please, Millards, but if the
What is-
35 lakhs that they've
No,
calculated is entirely illegal, what amount of it will I be payable?
No, there you have to pay 50%. Now for this 2 years, 24, 25, what would be the
Millards,
amount?
24-25, they've calculated, your lordships will see in the order, from December 2022 to August 2025, the amount is 2,09,000 Millards. December 2022 to August 2025, the amount that they have calculated is 2,09,000.
Then why, and what is this 48 lakhs?
Millards, that's for the whole period, Millards, from September to now. 2015 to now. They have calculated for April 2015 to November 2022, the charge that they've calculated is 33,22,000. From December 2022 to August 2025, the amount that they've calculated is 2,09,000. The total that arrears that I'm payable is 35 lakhs, not 44 lakhs. Millards.
According to you, the arrears are more from 15 to 22.
Please, Millards.
Arrears are more from 15 to 22, but not from 22 to 25.
Arrears can't, in any case, because of the lapse of the first proceedings, he can't look back from.
That they have calculated at it is 2 lakhs, the remaining is 33 lakhs.
Millards, if your lordships will see page number 90, it has the operative portion of the order. Point number 4, for period April 2015 to November 2022, the balance arrears payable amount is 33,22,000. So this entire period has to go back because this is from the earlier proceedings.
Then you pay this
From
amount.
December 2022 to August
Pay
2022.
this amount.
Millards, point number 4, Millards.
Point number 5.
Point number 5 is the December onwards, Millards.
Pay
December
this amount.
2,09,000 Millards. Certainly, I have to take instructions, Millards, but I will mention.
Stay on that.
Millards,
Stay on that condition.
please, Millards.
Yes. Then counsel appearing for the.
Millards, my connection has already been disconnected.
Then counsel for the.
I have a memo to show that the disconnection has already
Then
happened.
counsel for the petitioner submits that the authority has passed the order dated. What is the order date?
Millards, the order is dated 29th May 2026.
29.
May 2026.
What are you doing from there?
Millards, after that, Millards, I got the bill only in August, Millards. Sorry, only in July is when I got the bill. And I was in the process of preparing the writ and approaching, and by which time they disconnected, Millards.
There is no
I got the
mistake.
order.
If you wait till 3 months, what you will do? On dated 29th May 2026, whereby the petitioner is directed to pay an amount of rupees 33,51,745.
35 lakhs, Millards. The total amount.
35 lakhs. Accordingly, the total arrears 35 lakhs.
Correct. 35 lakhs, 31,745.
745 within a period of 15 days. The petition is before this court. Then counsel for the petitioner submits that. Though there is a remedy under 127 of the Electricity Act, Section 127 of the Electricity Act, that is not an effective remedy as he has to pay 50% of the amount as the order, as there is a manifest error from the face of it, where they have merged the earlier, they have now they want to recover from 2015 to 2000 to till 2025, and they relied on Section Electricity Act. What is the section?
126 Millards. 56 to Millards. The limitation.
56, Section 56(2) of the
Millards, in a
Act, and
similar
submits that.
proceeding in a earlier lordships had stayed it without any deposit requirement, Millards. In a matter your lordships had decided, passed an order. In a similar.
That is a different one. I remember that. That is about a charitable trust. I did it 2 days back.
Please.
Because every case I hear, so every order what I pass for a reason. So I remember everything.
Please, Millards.
56 under 57(2) or 56(2).
56 to Millards.
Under 56(2) of the Act. The 56(2) of the Act, there is a limitation, and beyond 2 years, they cannot recover the dues. It is submitted that in view of these errors on the face of it, the petitioner has come before this court. Considering the submission of the land council, in the order, it is mentioned that the balance arrears from April 2015 to November 2022 is an amount of rupees 33 lakhs 22,070, and for the period December 22 to August 2025 it is 2 lakh 9,675. In these circumstances, this court deems it appropriate to pass the following order. Number one, there shall be stay of all further proceedings pursuant to the order dated so and so, on the condition that the petitioner shall deposit an amount of rupees 2,09,675.
Can it be a part of this 2 lakh sum, my lords? The company is not doing that great. Can it be a part of the 2 lakh sum? Because the 2 lakh sum, it's also for 3 years. Going by the limitation period, it has to be 2 years. Can your lordships?
2,09,675 within a period of 4 weeks from the date of receipt of the copy of the order. Number two, the respondent shall forthwith restore the power supply. By the next date of hearing, the respondent shall file their objections.
Sympathy.
Great.
Yes.
Let's can I ask for the hand delivery of the order, my lords?
Seven Mother.
Yes.
My lords, I appear for the petitioner. I'm challenging the order passed under section 16(3) of the Indian Telegraph Act, my lords. There's no interim prayer in this matter, my lords. Notice may be issued to the respondent, my lords.
Mr. Devraju is directed to take notice on behalf of the respondent. Then counsel for the petitioner serve the copy of the petition on the counsel. Registry is directed to reflect the name. Yes.
Grateful, my lords.
Cell number 4. Amrit Chaudhary.
In favor of petitioner, my lord. The matter as per the matter was settled in the Lok Adalat, my lord, in 13/7/2019, my lord. Later, but the respondents, after the settlement, they have filed a new suit and taken the direction of the trial court, my lord. As per the annexure F, page number 54, my lord.
Page number 15.
56, my lord. The trial court has ordered about the direction, my lord. Under order.
What is this?
The order has been wrongly printed in the order sheet, my lord. As per rule 6, under section 6, rule 17, they have ordered about the matter, my lord. Because the matter has been settled, it's a violation of res judicata, my lord. The respondents have done the violation of the order.
Which is the suit ended up in compromise?
OS 245/2017, my lord.
OS 363 of 2019.
They have filed another suit when the matter has been compromised. In OS 245/2007, the matter was in local it was awarded, my lord.
Correct. So, why have you come before this court? You have to tell that court that earlier suit is compromised and they are filing a new suit.
We have made a submission, my lord, but
This is a 2019 suit. We are in 2026. Why are you before this court? Very strange.
the order was done in 2023, my lord.
Even after 23, we are in 26. We should have made an application before the court saying that already the suit is compromise is recorded in Lok Adalat.
Yes.
What do you want the court to do now?
Kindly direction may be given, my lord.
What? What direction?
The order may be recalled. 8/1/26 order may be recalled for make the submission.
Why should this order be recalled?
Because the matter has been awarded, my lord. Since res judicata, they have taken the position. Permitted the order to deposit the amount, my lord. Kindly.
You have given me now two options. You are leaving it there, or any more options are left?
No.
You say one suit is already compromised.
Yes, ma'am.
The one of the party has filed a suit in the year 2019. And
Yes.
now in 2020, now there is an I number, order 6 rule 17 is ordered.
Yes, ma'am.
Now you say that has to be set aside by this court because there is a compromise. And what are you doing all these years before the trial court? From the last, how many years? 6 years. Why you are filing these kind of writ petitions? Please come. The writ petition is filed, questioning an order passed with a. You better withdraw.
Madam.
You want me to pass orders on the merits of it?
Yes, ma'am.
Agreed with the order passed with the PCJ and JMFC Chintamani in OS number 3, in 9 number 5, in OS number 63 of 2019, dated 8/1. What is the date of order?
8/1/26, madam.
8/1/2026. The defendant is before this court. Then counsel for the petitioner submits that. That the respondent has filed OS number 245 of 2017 for declaration and injunction, and an award was passed on 13/7/2019. Thereafter, the present suit is filed in the year 2019. On 2/11/2022, the petitioner filed a written statement raising the bar of res judicata and limitation. On 5/9/2023, the respondents filed an application under Order 6 Rule 17 seeking amendment of the plain. The court allowed the same by order impugned. Then counsel for the petitioner submits that in the light of the earlier settlement, the present suit is not maintainable. Hence, the court ought not to have amended, ought not to have allowed an application filed under Order 6 Rule 17. And as such, the order has to be set aside. Next para. Having other counsel for the petitioner, there is a material on record. If the suit is not maintainable, that is not the ground for the court to dismiss an application that's filed under Order 6 Rule 17. The petitioner has to pursue the same and has to come before the court with appropriate application. But that is not the ground for this court to dismiss this application. Except that ground, no other grounds are stated. Accordingly, the petition is dismissed.
Cell number 4. 5. MB Anirudh.
My Lord, I appear for the petitioner. The petitioner is a decree holder before the trial court. It's a commercial court. Judgment debtor owes over 4.5 crore rupees. I filed IA number 1 seeking disclosure of assets under oath. However, the trial court directed oral examination. I did oral examination at length. He says, one, I have given I confronted the balance sheet. There is
every interlocutory order of a commercial court, you can't come to this court.
My Lord, because it's an execution proceedings, my respectful submission is that writ under 227 would be maintainable.
How?
Under supervisory jurisdiction, my Lords. It will not,
Everything
because it's not a final order.
No, every order, you can't challenge every interlocutory order unless and until there are certain parameters to interfere with an order by the commercial court. There should be a manifest error. Not every interlocutory order is amenable to 227.
My Lord, may hear me for 2 minutes.
Yes.
I filed IA number 1 seeking disclosure on assets under Order 21 Rule 41. Court directed oral examination under oath. At length, oral examination was conducted. The managing director of the company, that's the JDR number 1, was very evasive. He did not give any details of lands. He said, one, the landlord stole away all the machinery during COVID time. Security deposit under the control of the landlord, he said, has been adjusted to rental arrears. He said, bank has proceeded against me under SARFACI. I said, what about the details of bank accounts? He said, no, I do not know. Then he said, I've lodged a criminal complaint against the landlord. Asked, what is the status? He says, I do not know. I can produce details, but he doesn't produce. Then thereafter, about 1 crore is shown as due and payable by his own daughter's company. I said, what happened to that? He says, it has been adjusted against some material supplied. Last date of balance sheet is in 31/3/2019. company is not closed. He is not forthcoming as to what his assets are. Therefore, he is defeating the purpose of decree of the commercial court. Now I'm left with a situation where he's not disclosing on oath as to what his assets and assets are. So I filed IA number 2, again saying this oral examination has been to no avail. Therefore, kindly direct him to file his affidavit of assets. And that's what the Honorable Supreme Court says in its judgment of 2021. I'm not able to recollect the citation, but it says that when execution proceedings are there, court can resort to means necessary to direct a disclosure of assets. That's how the decree can be satisfied. In addition to that, I wish to place reliance on a judgment of this Honorable
Come to the
court.
order. Where is the order? First, let's look at
My lord, the order is at page number 28. That's on order number IA number 2. It starts, reasoning starts at para 7, my lord. If I may read. On an earlier occasion, DHRs had filed IA1 under Order 21, Rule 41 to direct JDR to file affidavit of assets of the JDR. By orders dated 12/11/24, it was held that there is no question of directing JDR to state on oath details of its assets because in the counter affidavit to IA1, it is already stated by MD of JDR that JDR does not own or possess any assets. However, acting under Order 21, Rule 41(1), this court directed personal attendance of MD of JDR for his oral examination in open court as to whether or what debts are owing to JDR and whether JDR has any and what other property or means for satisfying the decree. In pursuance of said orders, MD of JDR, Mr. So-and-so, was orally examined by counsel for DHR on 18/2 and further oral examination was deferred at request of DHR. At this stage, DHRs have come up with the present application. In the affidavit in support of the present application, stated that in oral examination, MD of JDR has not been forthcoming with straightforward answers regarding assets and therefore JDR should be directed to file affidavit of assets. At the outset, it's noted that the prayer in present IA to direct JDR 1 to 4 and directors of, I had also asked for disclosure because there were elements of transfer of assets to thwart the effect of the decree to their own family members. I had asked for assets and liabilities of the other directors who are none other than the wife and daughters of JDR number 2. So the court goes on to.
They are not the parties.
They are parties.
The court observes that.
Yes,
It is only
because
JDR
the
number
decree is only against JDR number 1. They cannot be directed to disclose assets and liabilities. I will not press on that. However, I had filed it with the intention to file an application for lifting of corporate veil because they have played fraud on that. Then, my lord, I will not read that particular portion. I will skip and go to page 31, para 12, because on the matter of distinct corporate liability, the court refuses to pass any order as against JDR number 2
not
to 5.
question this order dated 11/2024.
My lord?
Why you have not questioned an order dated 12?
My lord, in fact, I had challenged it in this very writ petition. Because of an objection of the registry saying I had to file 2 separate writ petitions, I restricted my challenge to the subsequent order. If I were to get relief in the subsequent order, I will be satisfied. That is why I have restricted the prayer to order on IA number 2.
But it can't be. Without questioning that order, you cannot file another application on the same relief.
My lord, then in that event, I will file a separate writ petition only challenging IA1 because it was it had come up repeatedly on office objections and there was emergency for me so that this matter gets listed. Because going by direction of Supreme Court and EP will be disposed of within 6 months. And there is extreme pressure at the trial court for me to take steps. He's not disclosing the assets.
In light of the order passed by the court specifically observing that you have not questioned that order of 2024, all the more necessary that you should question that.
I will file a separate writ petition on
And
that.
how can an order of 11/2024 you will question now?
No, because there was substantial time that passed in the oral examination and filing the second IA. And
when court dismisses your application and you go ahead with the oral examination, what does it mean?
That I have accepted whatever relief I got, I had accepted it then because at least let me elicit from the MD of the JDR number 1 as to what assets that are there.
But the fact remains is you have accepted.
Yes, I've accepted, but there he turned out to be evasive. Therefore, I filed the second application. My respectful submission is if order 41 is seen, rule 1, rule 2, rule 3, it works out like a waterfall mechanism. If oral examination I'm not satisfied, then the trial court can invoke sub rule 2 and say, I will disclose.
Here the issue is, what are the remedies? It is not about what the remedies are available to you. It's about what is the order of the court. Court has completely refused it.
On the basis of a simple.
No, it doesn't mean that if it doesn't work out, again you can go back to that.
Well, then I'll be before this court in a separate writ petition.
I don't know how can you challenge it now? I don't know.
If my lords were to kindly see the deposition of the witness, it starts at page 77.
Yes, notice to the respondent and summons.
Of the EP, let it be kept pending till such time this writ petition is disposed
It is
of.
in a way you are asking for a stay.
No, because I can I filed another application seeking production of documents regarding their particular assets. Now they refer to one PCR, one SARFACI, one bank account, and theft complaint. I've asked for disclosure of those documents. So at least there that can be proceeded with, or if the court were to state, I'll be grateful. Because I don't want to lose out on the EP. I leave it to the court.
I will not say it. That's what I'm saying. I can't do the other one also what you're asking. I can only give you a short date. You come, take out hand summons, let them come, I'll decide this.
Please, Madam.
Place this matter on 20th of August. The petition shall shall take out hand summons and shall place the memo by 19th of August. If it is memo is filed by 19th August, list the matter on 20th.
I may be permitted to serve the counsel appearing.
That's what.
Cell number 6.
Great.
MP Chandrachoda.
Plaintiff writ petition. The dispute is with regard to the passage which has to go through the land belongs to the defendant.
Yes.
An application was filed before the trial court for appointment of the commissioner to locate and measure the passage which is used by the
Suit
plaintiff.
is of which year?
Suit is of year 2019.
What is the present stage?
Present is cross-examination of PW1. The
Why, what
trial
is the
court,
necessity at this stage during the
the
cross-examination?
trial court rejected the application on the ground. It is nothing but a collection of evidence.
No, but at this stage, what is the requirement at the time of
Requirement is,
cross-examination?
Your Lordship may kindly take the judgment of this honorable court. At any stage, the commission
It can be done. It can be done. There is no doubt.
Please, so far as the appointment of the commissioner is concerned, the parameters have been called out in paragraph number 21 of the judgment.
I am aware of the judgment. I have seen that judgment.
Please. So my submission is, since there is a the identification of the road in question is concerned, any amount of evidence cannot be substitute the evidence of oral evidence of the party is concerned. If the report of the commission comes before the court, the entire evidence will be cut short. There is no necessity for me to examine other witnesses. Whether there exists a road or not is the only question.
Yes.
The trial court deferred the matter saying that you have to make an application after trial. And there is no bar as such for the trial court to
I'll
appoint.
record that. Please. Take the judgment.
Paragraph 13 refers to the stage of the application. Paragraph number 14 with regard to the oral evidence.
Yes.
Paragraph 18 refers to the examination of witnesses. Paragraph number 20, clause E, paragraph E. Then paragraph number 21, subpara 4, the dispute relating to the existence or otherwise of a stream, pond, drainage, watercourse, road, pathway, pollution, so and so. There is no bar as such for appointment of the commission even before trial. This is what the court said. It cut short the evidence of the parties.
No, for what you are reading 21?
Kindly see the
what did the court
guidelines
say?
have been made. Having
Guidelines are given. Having examined the provisions referred to above,
Please.
And given the fact, so this court is of the view, broadly speaking, the following cases, appointment of advocate commission, that's what the para says. Where it says that whenever you want, it can be appointed.
Kindly paragraph number 13.
Paragraph number?
13. 13. The next question is, at what stage the proceedings in a suit, the application can lie? As could be easily noticed that from provision, the provision is not a stage entry. Thus, the provision can be invoked either before commencement of the trial or after. If the application is filed before commencement of the trial, The court having regard to the pleadings and records may allow the application before commencement of the trial. For example, in a given case, if the report is necessary for consideration of an application seeking some interim measure before the commencement of the trial, the commission can be appointed. If the case is made out for such an appointment, order had again having regard to the pleadings and record, if the court finds that there is every likelihood that after recording the evidence of the parties, the need to appoint the commissioner may not arise, or at the court is of the view that it can take call on an application only after recording the evidence, then it may defer the order of application till such time. Thus, the decision as to when the appointment of the commissioner is to be secured must be taken, having due regard to the facts and circumstances. The distinction, though lies with the discretion, though lies with the court, as to the appointment of the commissioner before the trial or after the trial, the decision must be taken with due regard to the possibility of reducing or eliminating the need to record the oral evidence of the witnesses to prove an issue which could be effectively decided with an aid of the
Counsel
report.
for the petitioner submits that when an application is filed seeking appointment of commissioner, they came to be rejected by the court. The said application is filed at the time of examination of the witnesses. It relies on the judgment of a coordinate bench in case of Sadaksharappa versus Kumar Vijayalakshmi and others reported in 2023. One case is here 637. He relied on paragraph number 14. You are the plaintiff or the defendant?
I am the plaintiff.
So and so. The considering the submission of the. You want this suit to be stayed?
Please.
Why?
The report is enough for me to substantiate my claim.
The
Any amount of
considering
oral
the-
evidence will not substitute.
The judgment so and so, considering the order dated so and so. It shall be stayed for further proceedings, notice and summons.
Say number 7.
And summons. In all the cases, and summons memo shall be filed by 25th, or else the stay granted. 27. The or else the stay granted with court stands vacated. Yes.
Say number 7.
For the petitioner in this case, Your Lordships, this suit is filed for partition and separate possession, Your Lordships. OS number 1539 of 2021 was filed on 1/3/2021, Your Lordships.
What is the IA now?
This suit is actually regarding to expedite the matter, Your Lordships.
Which year? Let's see. Let's
2021.
come to the prayer. Why should we pass an order of expeditious disposal of 21 suit? That too, Bangalore.
Your Lordships, what has happened in this case is that actually the defendant number 1 has tried to execute a gift deed to a third party, and he's also trying to make some alterations in the buildings. So what has happened in this case is that unnecessarily is being taking dates in this case. Issues were framed. After the issues are framed, they're not coming before the court, Your Lordships. Unnecessarily the dates have been prolonged.
But that cannot be a reason for this court to issue a mandamus, because there are so many old matters are pending on the file of that court.
A small submission, at least notice may be issued with hand summons. Let them come before the court and answer the court.
What will happen then?
Lordships, no, any directions, Lordships, not just 6 months.
But pass any direction for a mandamus. The court is not supposed to. If a particular application is not heard, then you come before the court that it is pending. But we can't pass an order. Please come.
What has happened in this Lordship is actually the petitioner, the defendant number 1 and 3 are brothers in this case. All are joint family members for Lordships. And he has misled the court, telling that the father is actually, he's in the hospital and
Please understand.
Your
There may be
Lordships.
so many things on the merits of the matter. But High Court can't issue a mandamus just like that. In this CCH-3, there are several matters pending which are 10 years older to your case. And how can the court direct that to you? Please, you have come to the High Court. That's why 21 matter to be taken out of turn. Yes, the petition is filed seeking the following prayer. Considering the pendency on the said court, and as in the light of the judgment of the apex court, no exceptional reasons are stated for passing an order. Hence, this court finds no reason, accordingly dismissed.
Till number 8, Chandrasekhar Swamy KB.
Yes.
They appear for petitioners. Day before yesterday, in the connected matter, this honorable court was pleased to issue the hand summons to the council on record before the trial court and also notice to the petitioner, respondents. This is also connected matter.
List along with so and so, same order in that, whatever is the order.
Cell number 9, MS Nagaraj.
Lord, she's
Don't
the
have to give the order sheet.
The respondent in final degree proceedings, my lord, she is challenging the acceptance of the final report. My lord, in fact, my lord, the petitioner, they are not, my lord, the commissioner who has appointed, the taluk surveyor, is not conducted the survey of the properties and he has conducted this property survey other than the properties, my lord, which are belongs to the petitioner, other than the properties.
File your objection.
Your lordship, kindly 118, my lord. Even petitioner has opposed that, my lord, the report.
Let's see that order of accepting that.
Yes.
Page number.
118, my lord, please. Objections which filed by the petitioners, they oppose that. He has not conducted properly and not visited the spot.
Please come to the order.
118 annexation, my lord.
Read.
Page 118. The objections filed by the petitioner itself.
Please come to 121.
Hello?
121 is the order.
Yes. Yes. The order, my lord, the final decree proceedings initiated by the petitioners, plaintiff in provisions of the preliminary decree passed in OS number 30/2013. Petitioners who have in decree orders in OS number 30/2013 awarded with 1/6 share in each of the scheduled property, and respondent 1 and 2 were allotted 1/3 share in each of the scheduled property by decreeing the suit on 18/3/2015. The judgment and decree in the said suit remained unchallenged so far. It has attained the finality. In spite of the decree passed, the defendants have not obeyed the decree. Therefore, the petitioners have filed the present petition for seeking decree proceedings allotment of their share. After presentation of this petition, notice were issued. Respondent, those served the notice remained absent. They are placed export. During the pendency of the petition, petition number 2 reported to be dead. Hence, these LRs are brought on record. Thereafter, get allotment as per the share decreed by this court in preliminary decree. This court has appointed the court commissioner to assist the court in partition the suit scheduled property by meets and bounds. Accordingly, the court commissioner was appointed, and in pursuance of his appointment, commissioner was warrant is issued in his favor. Thereafter, commissioner has executed the commission work.
That even the petitioner, the respondent
next, Allah.
For petitioner, after verifying the report, stated there is no objection to report and accepted the report submitted with the court commissioner.
Like, I have produced, my lord, I have produced the copy of which they have produced. None property. The property which is not, my lord, subject matter, they are measured.
I understood. Please follow what the court is saying. You said even the respondents also have raised objection, but the court records that the respondent has accepted it.
We are not accepted, my lord.
Respondent before this court. I'm referring to
My
respondent.
lord, commissioner wrote this report. Thereafter, he's done his commission work with the respect of item number 2 only. Item number only. After submission of the report, objections of the report was called for counsel for the petitioner. After verifying the report stated therein, no objection to the report accepted the report submitted by the court commissioner.
The petitioner submits the court has appointed the commission, the final decree proceedings, and the petitioner has filed his objections to the report as he has not, as per the warrant issued, he has not submitted the report. And in the court has accepted the said report without even considering any of the objections that are raised by the petitioner. Considering the submission of the land counsel for the petitioner, it shall be stay of all further proceedings in FTP number so and so.
10.
Please hand summons.
Cell number 10, Andal Lingappa.
I prefer question in this case. My lord, the defendant number 3 is the minors and represented by natural mother has filed this petition challenging the order passed by the trial court dated 18/3/2026, rejecting the return statement filed by the minors and challenging that order.
This is a delay.
Page number 37 is the order passed by the trial.
Delay.
120 days, beyond 120 days we have filed this return statement. That
Behind 120 days, there will be some other days. How many days?
When
was the suit? Suit is of the year 2025.
12 days delay.
Please come. Let counsel for the petitioner submits that there is a delay of 12 days in filing the written statement. In the light of the amended provision, the court has refused to take the written statement on record. It is submitted that the coordinate bench of this court has stated the operation of the amended provision, and also later the award bench has also observed that the court can condone the delay. Considering the submission, there shall be stay of all further proceedings pursuant to notice and summons. Yes, next.
7 to the CS.
Propose the petitioner in this case. This is challenging the order under 22 rule 10, my lord. The applicant has filed an application before the final decree proceedings to include himself as a deceased first respondent Boregoda has executed a will in his favor, which the petitioners have resisted it, my lord, because the petitioners are the heirs of the said Boregoda, wife and her son. This will has been, that application has been allowed, my lord.
Para 8. Para 8.
Para
8.
8, much of them, sorry.
Push it little forward. This mic. Push it little forward. Yes.
But this contention of the respondent 2 and 3 are not acceptable. Thereafter filing the application, the applicant has led the inquiry on the application. Apart from examining himself as AW1, he has also examined an attesting witness AW2. Applicant has produced the original will under A1. Exhibit A1 is a registered one. Both PW and 2 are clearly spoken of the execution will. At this stage, there are no reason to discard the disbelief of the version. All these objections raised by the respondent 2 and 3 in the objection can be raised during the merit of the case. The decision rendered upon the applicant or rendered in so and so, and in the
What
case.
is wrong with this order? What is wrong with this order?
My lord, they can't file it in before the final legal proceedings on the will. He can't claim the share. He can file a separate suit against that and he ask for partition, but he can't do it in this decision proceedings, my lord. First point.
A particular share has fell to a person A. A has executed a will in favor of B. So why can't B be there before the court? Why should there be multiplicity of proceedings? And the court in the execution proceedings as well decide if you deny that fact, that can be decided. That is what precisely the court said.
My submission is that my shares would not be snatched.
Not your share. Not your share.
No, even
share of the deceased.
Even the deceased.
Do you want? No, according to you, are entitled for the share of the deceased.
Deceased. The petitioners are not, nobody than the wife and the son of the deceased, my lord.
Who is this?
Swami, he is the first respondent. That is the deceased sister's son is.
So
sister has filed a suit.
You can always agitate that he has no right to execute the will, or when the rights are crystallized, when this will is executed. All this can be decided by the court.
That observation will be made that I have no.
Court is already observed.
The court, see, the appellant court was the first appellant court has made, my lord. That is why I'm worried, my lord.
No, I'm looking at order at page number 29. 29 is the order, not 68 is the order.
68, no, I'm saying the first appellant court in MA, the reasons what the first appellant court has passed, my lord. Yes, said in page number, continuous page number 88 and 89. No, 89. Page number 90, my lord. The MA copy is page number 12, last para. There is no suspicious circumstances brought out by the respondent 2 and 3 in execution of A1 will. Therefore, the learned senior civil judge rightly came to the conclusion that the
I'll observe that. I'll observe that. That it is left open.
That's what I want, my lord. That's observation should be there. That's all.
The petitioner
I can sit, my lord, I can't stand.
Please, please. The you're the execution is filed by you.
FDP filed by the first respondent.
You're the respondent in the execution.
In execution, I'm the JD as well. Is a FDP, final degree proceedings.
In a final degree proceedings, the petitioner owes the respondent has questioned this order passed on I number 2 in FDP number 10 of 2028 by the senior civil judge Madhur, dated 22/1, dated 26
First order is on 31/8/23.
Passed on I number 2 dated 14/8/2023, which is affirmed by the court, appellate court in MA number 18 of 2023, dated 12/9/2023. You are questioning this order now.
I'm challenging both the orders.
In 2026.
No. May 18 of 23. MA of 18/23.
Order is also passed in 23.
Yes.
And you are questioning it in 26?
No, not 23, my lord. It is passed on January 29/1/2026, my lord. This year only it is.
In facts of the case, you have written it as 23.
My mistake, typewriter.
As confirmed the order, by order dated 29/1/2026, the petition is before this court. In the execution, an application is filed under order 22 rule 10(1), read with section 151 CPC, to grant leave to the applicant to come on record in the place of respondent number 1 as his legal representative, since his share has been devolved upon him by virtue of the will dated 6/9/2013. The executing court, by order dated 14/8/2023, had dismissed the same, had allowed the same. While allowing the application, the court has observed that after filing the application, the applicant has led the inquiry on the application. Apart from examining himself as AW1, he also has examined an attesting witness as AW2. Applicant has produced the original will under Exhibit A1. Exhibit A1 is a registered one. Both PW1 and 2 have clearly spoken about the execution of the will dated 6/9/2013. At this stage, there are no reasons to discard or disbelieve the version of AW1 and 2. All the objections raised by the respondents number 2 and 3 in the objections can be raised during the merits of the case also. And accordingly, the court has observed that the prima facie, the documents produced by the plaintiff show that the late Boregowda has executed a will dated 6/9/2013 in favor of the applicant, and as per the said will, the interests of the deceased respondent number 1 is devolved upon the present applicant. Therefore, the presence of the applicant is very much necessary, and accordingly, the application is allowed. Agreed thereby, the petitioner has carried it in appeal by filing MA number 18 of 2023. That came to be dismissed by order impugned
29/1/26. 29/1/26.
Wherein the court, the appellate court, had observed that Exhibit A1 is a registered will dated 6/9/2013, and it goes to show that the deceased Boregowda bequeathed his property in favor of the applicant's farming. To prove the said will, the applicant examined as AW1, and he has spoken with regard to bequeath by Boregowda in respect of suit property in his favor. He examined the attesting witnesses of will, and he narrated the execution of will. In the cross-examination, the respondent 2 and 3, though questioned with regard to the manner of execution of will and registration, nothing material elicited to discard the execution of the will. Indisputably, the respondent number 2 and 3 are the son and wife of deceased, Boregoda, and applicant is sister son of Boregoda. On perusal of Exhibit A1 will, it appears that there is specific reason for excluding the respondent number 2 and 3 from inheritance to his property and reasons for execution of the said will. There is no suspicious circumstances brought out by the respondent 2 and 3 in executing Exhibit A1 will. Therefore, the senior civil judge rightly came to the conclusion that that prima facie Boregoda executed will dated CH-19 2023 in favor of the applicant, and from the said will, the interest of Boregoda will devolve upon the applicant Swami. Therefore, there is no illegality in the order. Next para. When counsel appearing for the petitioner submits that these issues cannot be decided in the final decree proceedings, it is submitted that the appellate court has given the findings as if the will is already proved and the applicant is entitled for the right in the property of the deceased. It is submitted that the appellate court has exceeded the jurisdiction conferred and made certain observations which will have an impact on the petitioner's case. It is submitted that the order impugned needs to be set aside. Next para. Having heard the counsel for the petitioner, produce a material on record. An application is filed stating that one of the co-sharer has executed a will in his favor. That is resisted by the family members. The trial court has held that he has placed the will on record. The attestors of the will are examined. Prima facie, the applicant would show that there is a will executed and as such is a proper and necessary party. Whether the will is genuine or not and other things can be decided by the court during the course of trial, during the course of evidence. When the matter is taken to the appellate court has also affirmed the order. However, certain positive observations are made by the court. In the considered opinion of the court, the executing court is empowered to deal with all these aspects, and had rightly the trial court has allowed the application. Hence, this court is of the view that there are no reasons to interfere with the order passed by the trial court. However, uninfluenced by the appellate court ought not to have made those observations. In that view of the matter, this court is passing the following order. This court do not find any reasons to interfere with the order impugned. However, who's talking continuously? However, uninfluenced by any of the observations made by the appellate court, the executing court shall consider the case of the respective parties on the merits of the matter, accordingly disposed of.
Seal number 12. Secretary Shripad Gupta.
For a week's time because I could not brought my file with this mistakenly some other file I brought it. It is
Yes.
regarding compensation.
BESCOM matter.
Yes, my lord. BESCOM, my lord.
Where is the name?
225 is the BESCOM, my lord.
You take
It's the
notice.
state. One is the state, my lord.
It's HCGP takes notice on behalf of the first respondent.
225 are the BESCOM.
Huh?
225 are the BESCOM.
2 to 5.
Yes.
Mr. B.S. Karthikeyan is directed to take notice. Let it consider the petition or the copy of the writ petition on the council. This is matter after 2 weeks.
Seal number 13.
The petitioner, the petitioner being the plaintiff before the trial court, has filed a suit for partition in separate position against the respondents hearing lords. But the continuation of the plaintiff before the trial court on 25/2/2026, that is a page number 54, there is a Kannada copy, my lords, the consent letter fabricated by the respondents in order to get the name of the plaintiff in the revenue records. and based on which they are trying to alienate the property concern. So based on which she filed a suit for partition and separate possession. Along with plaint, she has also filed application for not to alienate the properties concerned. The learned trial judge, instead of considering the application, simply issued emergent notice.
Where is that?
Please, notes. The operative portion of the order starts from page number 11. Page number 14 is the order. Page number 14 does not consider the applications. Issue suit summons and the emergent notice.
Land Council, and not like the writ petition is filed, agreed with the order dated 30/6/2026 by the second issued senior civil judge Nel Mangala in OS number 685 of 2026. Land Council for the petitioner submits that the petitioner has filed a suit for
Partition and separate possession.
suit for partition and separate possession, and also filed an application I number 1 seeking ad interim injunction
For not to alienate.
restraining the defendants from alienating the property. The court, without passing any orders on the merits of the matter, has issued the suit summons. He has relied on a judgment of the coordinate bench of this court in so and so. There is a order in this class. The has issued the suit, has relied on a judgment of so and so, considering the submission of the Land Council and the judgment of this court in so and so. The writ petition is disposed of. Accordingly, the writ petition is disposed of, directing the court to consider the IA with a period of 1 week from the date of receipt of the copy of the order, notwithstanding the fact that the notice and summons were not served on the defendants. Yes.
Cell number 14, Balgandhar GS.
Yes.
My lord, defendant's writ petition, my lord. The respondent filed a suit for specific performance, my lord. After filing of the suit, my lord, he files another application for injunction not to interfere. The agreement in question is disputed by the petitioner's defendants, my lord. Then a criminal case is also filed alleging forgery.
Where is the IA?
Please.
What did the trial court do?
My lord, the trial court rejected the injunction application.
Appellate court also.
Appellate court allowed. Therefore, I am before your lordship.
The defendant.
My lord,
You are the defendant.
I am the defendant.
Yes.
My lord, the way, my lord, the first appellate court considered and rejected the trial court's discretion is not proper and correct. There, my lord, I humbly invite the indulgence of the honorable court.
Which paragraph?
My lord, your lordship may kindly peruse the para number 17, page 62, my lord.
Para number?
17. This is in MA, my lord, page 61, 62.
Yes, let's read.
In order to consider the, may I read, my lord? This is where, my lord,
Para number?
Para number 17, my lord, page 61, MA 14 of 24, my lord. There, my lord,
We'll read the order.
Please. May I read, my lord? In order to consider the said point, it is found necessary to refer the findings recorded by trial court, wherein it has been specifically held that since there is an averment regarding the delivery of possession as a part performance in the sale agreement, it requires registration under section 17A of Registration Act, and therefore the said document held as cannot be relied upon at this stage. With the backdrop of the above aforesaid findings, it is necessary to refer Article 5E of the Stamp Act, which provides that whenever an agreement of sale of immovable property is entered into and possession is delivered, the stamp duty shall be paid on the market value of the property. And in view of the voluntary payment of deficit stamp duty and penalty under the orders of the district registrar dated 10/8/23, it is sufficient to presume that document contains proper payment of stamp duty with penalty. As per section 17A of the Registration Act, documents containing contracts to transfer consideration of any immovable property for the purpose of section 53A of TP Act shall be registered if they have been executed on or after the commencement of registration and other related laws Act 2001. And if such documents are not registered on or after such commencement, then they shall have no effect for the purposes of the said section 53A. Said provision of law was given effect from 24/9/2001, but the sale agreement in question is dated 30/4/2001, much prior to the commencement of the registration and other relates laws amendment Act 2001. Thus, it is crystal clear that section 17A of Registration Act has no application to the alleged sale agreement in question. At the same time, it is also necessary to refer 53A of Transfer of Property Act, which explicitly states that whenever a transferee has taken possession under the contract and continues in possession in part performance of the contract and has done some act in furtherance of contract, and the transferee has performed or is willing to perform his part of the contract, then notwithstanding that where there is an instrument of transfer, that the transfer has not been completed in the manner prescribed under law, the transfer or any person claiming a transferor or any person claiming under him shall be debarred from enforcing against the transferee any right in respect of property which the transferee has taken or continued in possession other than the right expressly provided by the terms. My lord,
I've seen that.
please. My lord, my submission is this, my lord. Date of filing the application may kindly be perused. The date of events in the synopsis may kindly be perused. Before filing his suit for specific performance, my lord, I filed a suit for injunction in OS 471 of 23. That was an earlier suit 25/8/7/23, my lord. I denied all these allegations. Then, my lord, he files a written statement. Then on 12/10/23, kindly appreciate, my lord, subsequent to my filing of the suit for injunction, specific performance is filed. And relief sought in this suit, which is filed on 12/10/23, my lord, Annexure A, only for specific performance, no relief for injunction is sought by him. Page 19, my lord. Then, my lord, the 11/1/2024, we filed.
One minute.
Please.
You have filed a suit OS number 471.
Please, on 28/7.
Seeking injunction.
Yes.
Ad interim injunction.
No, my lord, it was not granted. Notice was issued.
Then he has filed.
Then he filed this suit.
So
My
he
lord,
has
kindly appreciate, my lord, he files an application for injunction. Next page, my lord, item number 7, 27/9/24, this injunction application came to be filed.
What is this OS number 676?
676 is the present suit, my lord.
Is
That-
for injunction.
This is, no, this is specific performance,
Yes.
in which he seeks injunction. My lord, kindly appreciate, my lord, date of filing of the suit and also, my lord, date of filing of this application. This, my lord, suit at Annexure A, blind, page 19, is on 9/10/23. And he files injunction application, my lord, kindly appreciate, my lord, that's at Annexure E, page 29, is on 27/9/24. Subsequent to all these developments, he files an application for injunction.
No, forgetting about all this.
Please.
What is the material before the court? How he has shown prima facie?
Only except agreement, my lord, no document is produced. That is what, my lord.
What does the agreement say?
Agreement says there is delivery of possession. But the question remains is, my lord, the trial court considered this aspect. Now, kindly appreciate, my lord, the trial court's order, your lordship may kindly appreciate at page 38. That is the Annexure C.
No,
G.
at this stage, that agreement with delivery of possession is not sufficient.
Not sufficient. Reason is this, my lord. Reason is this. My lord, the conduct with regard to the,
What are the other documents placed by the plaintiff?
he says that subsequent to filing after that, some receipts are produced, tax receipts.
For
Now, yes, now, my lord, under the agreement of sale, my humble submission is there cannot be entry in RTCs. It cannot be. Secondly, he himself approaching the registration authorities and getting it registered on his own, subsequent to agreement. And my filing suit, now, my lord, if he is very conscious and confident and ready and willing, even if I go a step further, submitting, praying the honorable court that you should have filed this suit on the earlier.
Filed the written statement in your suit.
Yes.
In the written statement, has he taken the plea that he is in possession of the property?
My lord, that I have not produced, my lord. That because subsequently it was.
That will clinch the issue.
Well, may produce that documents also. Kindly, my lord. Because only one line may bring it to your lordship's consideration. First, trial court considers all these aspects. With regard to the registration, let me say that it may not be present now. But so far as delivery of possession and denial of agreement, my lord, prima facie is there on my side. And filing of criminal case, my lord, at the earliest by me by filing a PCR. That clinches.
Why the court has not granted injunction in your favor?
That notice is issued, my lord. My lord, I'll produce that document.
Notice to the respondents, hand summons.
Please.
By the next date of hearing will encounter the petition shall place before the court.
Both by summons and.
The written statement that is filed in the suit for injunction filed by the respondent.
My lord, both
List,
both court proceedings by notice may kindly be,
notice, sir.
and by court and my lord, I may permitted to serve one.
I said so.
Please, much of
H date
date,
number.
date,
This is a matter on 9th of September.
please.
15.
Paying for the petitioner, my lords, it's defendant's writ petition, my lords. What has happened, my lords, that the respondents plaintiff has filed a suit for bare injunction, my lords, claiming that they have purchased the property under some sale deed.
What is IA?
IA was filed for injunction and it was allowed in their favor. Then they have filed a subsequent IA for police protection, my lords, which we have challenged. The impugned order is passed by the court to give back.
So what happened to that interim injunction? Is it questioned?
Interim order we have not. That injunction order we have not challenged.
Then
We are,
without questioning, how can you question this?
my submission would be, my lords, we are in possession for last 40 to 50 years.
How will you say that?
By way of adverse possession, we are there.
No,
It's an agricultural land.
Having suffered an injunction order, without even questioning that order, you say that I am in possession, that is not acceptable.
Like my
We can't appreciate that submission. Had you questioned that injunction and that by placing the necessary material, if you can prove, that's a different aspect. When was the injunction order granted?
24/1/2026 minutes.
Almost 6 months.
But we are in possession. Possession is not taken away by us. 25 to 2026.
Why the court will grant injunction? What is the finding of the court? That he is in possession of the property.
Court
would be the
finding is on the basis of the document, the mutation, RTCs.
Then what are you doing from the last 6 months? Having not questioned that order, you cannot question the subsequent police protection order pursuant to for implementation of that.
Now, because of this order, they are coming and trying to dispose us from the piece of land.
Court has all sympathy for your client, but the court can't help it.
It's an agricultural land, my lords. We are in my contention, the adverse possession.
Why you have not questioned? Now you tell the court.
I will advise them to question injunction.
Let them do it. Please come.
Notice maybe. In the meantime, I will question the injunction order also.
Notice to the respondents and summons.
Obligations.
Yes.
Cell number 16.
And for petitioner in this case, Your Worship.
Yes.
I'm challenging the dismissal order passed in under Order 14 Rule 5 of.
Just at my properly. Yes.
Dismissal order under Order 14 Rule 5 of CPC, Your Lordship.
Come to that order.
It's in page number 15, Your Lordship. 12 to 15. The page number 4, he observes that in such
1 minute.
In such circumstances, the plaintiff has to substantiate her title. She shall also prove the execution of the will dated 4/10/2018. In such circumstances, the question of sound and disposing state of mind of executant of the will has to be established by the plaintiff independently, thereby framing of separate issue with respect to prove the sound and disposing state of mind of the executant is not required in the suit. He opines that the plaintiff should prove the case independently, but he rejects my application asking for separate issue, Lordship.
No. The issues in the suit will be framed basing on the pleadings of the parties.
Yes, Your Lordship. You have clearly pleaded.
Without a pleading in the written statement, why should it be proved?
We have clearly pleaded in the written statement, Your Lordship. It's in page number.
So before that, we'll complete reading this order. Come to para 6. Para 6.
On pursuit of the merits placed on record, the present stage is for cross-examination of PW1. At this juncture, the defendant number 1 has come up with the application frame an additional issue as proposed in the application. It is to be noticed that this court has already framed the issues, and the burden is casting upon the plaintiff that she shall prove her ownership and possession over the suitable property by virtue of the will dated.
For the earlier issues framed, point out that.
Lordship, it's in page number 34, Your Lordship. The first issue, whether the plaintiff proves that she is the absolute owner and possession over the suitable properties by virtue of the will dated 4/10/2018. In a written statement, Your Lordship.
No, 1 minute. In this, this issue number 1, the burden is cast upon the plaintiff. Plaintiff has to prove the will.
Yes, Your Lordship.
When it comes to proving of the will, all these issues will be covered in that.
Lordship, the absolute ownership and possession is very different from the
No.
the sounds.
By virtue of the will. By virtue of the will means will has to be proved.
Yes, Your Lordship. But the will has been executed 6 hours prior to the death, Your Lordship.
No, he has to execute. You has to prove the will by this issue number 1. That is what precisely the court also has observed. There need not be any another issue on the same thing.
But the sound disposing state of mind was not there. Admittedly, he was a cancer patient, Your
No,
Lordship.
when he has to prove it, he has to prove that. You will get an opportunity to
But, Your
cross-examine the
Lordship,
witnesses.
at the time
that,
of cross-examination, we have to see the issues which was framed, Your Lordship.
no proving of will, it covers all this. There need not be an issue on that. Yes.
Your my lord, also if this issue frame, no impediment to the plaintiff, my lord. If this issue
Not
is
at that
framed,
stage.
my lord,
Why,
if-
just for the sake of asking, why should it be done? When already the other issue covers this. Please come. Agreed with the order.
at least notice
Pass.
may be issued.
Notice
Huh?
may be issued, Your Lordship.
Notice may be issued.
IA number 7. In OS number 123 of 2020. Dated 15 July 2026. By the civil judge and JMFC at Mood Bidri, Dakshina Kannada. The defendant is before this court. They filed an application under Order 14 Rule 5 of CPC, seeking the court to frame an additional issue whether the plaintiff proves that late Sridhara Pujari has executed the will dated 4/10/2018 voluntarily in favor of the plaintiff when he was in sound and disposing state of mind. The court had rejected the said application. While rejecting the application, the court has observed that the present stage is for cross-examination of PW1. At this juncture, the defendant number 1 has come up with this application, trying to frame an additional issue as proposed in the application. The court observed that it's already framed an issue, and the burden is cast upon the plaintiff that she shall prove her ownership and possession over the sue scheduled property by virtue of the will dated 4/10/2018. In such circumstances, the plaintiff has to substantiate a title. Shall also prove the execution of the will dated 4/10/2018. In such circumstances, the question of sound and disposing state of mind of the executant of the will has to be established by the plaintiff independently, thereby framing a separate issue with respect to prove the sound and disposing state of mind is not required in the suit and accordingly dismissed. Then counsel for the petitioner submits that this application is filed when the matter is coming up with the cross-examination of PW1 by framing this additional issue. No prejudice would be caused to the plaintiff. It is submitted that the court has observed that in issue number 1 already this issue is covered, but the counsel submits that the additional issue which they are raising is not covered by the first issue. Thereby, they will only proving their right and title to the property, but it won't amount to proving the other issue that the defendant is in a sound the will was executed by Sridhar Pujari voluntarily when he was in sound and disposing state of mind. It is submitted that the court has failed to consider the grounds that are raised next by having with the counsels on either side, but is remitted on record. Already with regard to the will and by virtue of the will, whether the petitioner, the plaintiff has become an absolute owner of the property, an issue is framed. Now the issue that the petitioner wants the court to frame as an additional issue is that whether that will is executed voluntarily in favor of the plaintiff when he was in sound and disposing state of mind. Then the petitioner, when the plaintiff has to prove the will precisely, these are the issues that would be decided by the court. And in the order impugned, court has rightly observed. In those circumstances, the framing of additional issue is unwarranted and the court has rightly dismissed. No reasons to interfere. Yes.
Cell number 17, Dangi Reddy.
Yes.
Lord, the plaintiff filed the suit, that is petitioner filed a suit for permanent injunction against the respondents. Lord, here
during the pendency of the suit. At first occasion, there was an injunction granted in favor of the ex parte order passed in favor of the
You filed an application
petitioner,
under Order
and it is
6270.
yes, my lord.
Let's see.
The injunction is operating still. My lord,
What is the suit for?
suit for only for bare injunction.
Yes, what is this amendment you are seeking?
Amendment is, my lord, during the pendency of the suit, Akarband was changed at the instance of respondents. At the instance of respondents, that is, Joint Patrol Land Records has changed the Akarband. Now, the southern boundary, the eastern boundary, now little changes is there. That's why I sought for declaration that is done during the pendency suit without permission of the court. The Joint Patrol Land Records has changed the Akarband. That's why, my lord.
No, if number is changed, you will seek for change of that. That in view of the whatever the subsequent developments, you will only ask that you will amend the prayer as far as that is concerned. Where is your declaration has come in this?
But here, due to change of Akarband, now the eastern boundary is changed. That's why, my lord, I filed a suit for declaration to declare that the boundaries given in the suit is within the boundaries of the paid property is the owner, to declare that he is the owner of the property. Because of the change of Akarband, there is a little change in the suit schedule property. That's why, my lord, I filed a suit for declaration that is done during the pendency of the suit without permission from the court.
Come to your IA.
It starts from page 30, my lord. Annexure E.
26, I think.
My lord.
It is 26. Your affidavit is 26.
Page number 26. Affidavit. During the pendency of the suit, the defendant, through the high and influence of third defendant, got altered the Akarband sketch of the suit land, which is to create hardship and injustice. The act of the defendant is to exploit the situation to their unrighteous advantage and to infringe our right. The act of the altering the Akarband sketch is without permission of the Honorable Court, and it took place when the litigation is pending and it is pendent right development. I state that in view of the said development, it will be constrained to amend the plaint to seek full relief as per law. Hence, we propose to amend the plaint as shown in the application to get legal relief to avoid multiplicity of suits. The property involved in the suit and the parties are one and the same. Hence, no fresh suit is warranted in law. The proposed amendment is, if permitted, would have precious time for the Honorable Court and the parties to the suit. I state that the proposed amendment of the plaint will not create hardship or injustice or application, if allowed, as prayed for, will help both the parties to get justice and per law. Hence, I pray this Honorable Court to grant the application as prayed for. This is the affidavit I filed, madam. The order, your lordship may kindly see. The reasoning given by the court, well, it starts from page 34. The present suit was originally instituted seeking the relief of permanent injunction. By way of present application, the plaintiff seeks to incorporate an additional pleadings alleging that during the pendency of the suit, the defendants have illegally altered the Akarband sketch of the suit property. On the strength of the said allegation, the plaintiff further seeks to introduce substantial relief of declaration of ownership and declaration of boundaries of the suit property. The proposed amendment also seeks to substitute existing boundaries description with a new set of boundaries. New set of boundaries, not other boundaries, only towards eastern side, road margin and the Kushal Nagar road. That is only the road margin we are asking to add. That is only the alteration we seek in the boundaries. That not more than that. The remaining boundaries are the same. What I have stated in my original plight. Principal condition of the plaintiff is that alteration
that
of the.
True. What I am not able to understand is what is this declaration? Now, original suit is for injunction. If they have changed, you will say, in view of that, these are the changed boundaries of the As per that.
Yes.
Why this declaration has come in between, that I'm not able to understand.
My lord,
That cannot be a reason for declaration. And you cannot seek declaration whenever you want. Because the suit is filed in the year 2020.
my lord, during the pendency of the suit, soon after the change of declaration of the Akar Bandh, the defendant entered my property towards western side and occupied 2 cents of land in my property. 20
Where
out
did
of
you-
20 cents.
Where did you say?
That I have not said, but the
have to
Akar,
seek-
due to the change of Akar Bandh.
Then you have to seek recovery of position also.
Allala, due to change of Akar Bandh, and boundaries are seek declaration. This is the prayer, my lord, in the application. Lordship may kindly see. My prayer is in the application at 5A. 5A in the body of the plaint. The plaintiff submits that due to the high-handed influence of the third defendant, the boundaries of the suit property is illegally got altered to the unrighteous advantage of the defendants, which amounts to infringement of the right of the plaintiff. The defendant got altered the suit schedule plan and Akar Bandh sketch without seeking permission of the Honorable Court. And the said alteration.
What is the present stage of the suit?
My lord,
What is the present stage of the suit?
suit. Suit is the PWD1 evidence is closed. Now set down for class examination PWD1. For class of PWD1, not even started the class examination.
Let respondents come and tell the court, I'm not able to understand this amendment. Notice to respondents. Petition is permitted to take out handsome and file a memo to that effect.
Right.
The
Meanwhile,
memo-
the case is set down for class examination on 20th my lord, of this month.
Later, I'll post before that. Let's this matter. If the memo is filed by 18th, let's this matter on 19th.
Still number 18. Mohan BK for petitioner.
Petition, my lords.
Yes.
My lords, this is a petition where the allowing of the amendment is under challenge, my lords.
Yes. Not required. Fresh matters. Yes.
My lords,
Yes,
this is the petition by the defendant respondent, my lords, where the allowing of the amendment petition FDP is under challenge, my lords. Originally, the suit was filed by the plaintiff for partition, my lords. Thereafter, it comes to be allowed in part, my lords. Then an FDP petition is filed. During the pendency of the FDP petition, my lord, the plaintiff seeks for the demarcation of the property by appointment of the commissioner, my lords. The commissioner, he returns the memo saying, he returns the warrant saying that since the property's durasti has not been done, it is not possible to demarcate the property, my lords. So thereafter, the plaintiff, he files a memo saying that now durasti has been done and the property number has been changed by virtue of this durasti, as a result of which he seeks amendment of the petition, my lords. My lords, in fact, he is trying to bring a new property to the suit schedule property by wrongly claiming that the number has changed, my lord. In fact, what number he is claiming, that's a totally a different property, belongs to me, and it's a grant land, my lords. And
You
at
are-
that, I am for. I'm
You are the
defendant.
obstructor.
No, I am the defendant, my lords, and that property which he is trying to bring now is my separate property, which has got nothing to do with the partition, my lords. It's a separate property. It was separately granted to me. It was never the subject matter of the suit schedule, my lords.
Come to the order. Order.
Yes, my lords.
There are no proceedings renumbering this.
No, my lord, there is no proceedings, my lords. In fact, what he claims is that property number 82, it is totally a different property, my lords. That trial, what has happened is, my lord, I could not file my objections because I was suffering from the spinal disorder, my lords. And the court took my objection as nil after giving me opportunity and mechanically passed the order allowing the amendment, my lords, without looking into the fact whether both the properties are same. In fact, if your lordship were to look into the original property, that is suit schedule property, it is only 4 acres. Now, after renumber, he claims that it becomes 4 acres, 16 guntas, my lords. This has not been explained. 4 acres, 16 guntas, my lords.
4 acres, 28 guntas now, totally.
Totally, my
Now-
lords.
now come to
Originally,
the plaint. Come to the plaint.
my lords.
Plaint.
Yes, my lords. In the plain, my lords, the item number 3, my lord, land bearing survey number 25/72, measuring
Page
4
number.
acres. My lord, sir.
Page number.
One second, my lords. My annexure A, my lords, page 14, I see, 14 it appears, my lords. I'm sorry, my page number is not telling with the tough court, my lords. It is annexure A, my lords. Last
There
but
are,
three.
there are about 10. There are about 10 properties. Which property is this?
Serial number 3, my lords. In the schedule, serial number 3, my lords. That is 25/72, my lords.
Measuring 4 acres situated. Now it becomes 4 acres.
No, that is what the plaintiff claims, my lords. But it is not so, my lords. What he claims is so totally a different one, my lords. That is a grant land, my lords. He is claiming that grant. He is saying that 25/72 has now become 281/2 and 282/2, measuring 2 acres 12 guntas and 2 acres 16 guntas, which is not correct, my lord. In fact, it's a granted property, my lords. This 282.
Where is the judgment and decree? Please come to that.
My lord, I am not telling the judgment and decree, my lords.
That I understand. I just wanted to see where is it. Please come. When counsel for the petitioner submits that, the respondent herein filed an application under Order 6 Rule 17 to amend the petition in order to include the words in the second line of the suit, item number 3 of the petition, within brackets, within inverted commas, subsequently subjected to duress by the government and renumbered as 281/2, measuring 2 acres 12 guntas, and 282/2, measuring 2 acres 16 guntas, totally measuring 4 acres 28 guntas. The court has allowed the IA. I'm told this, they say that already preliminary decree is rectified.
That's what in the FDP it was rectified. First it was allowed in FDP, my lord. Thereafter he was asked.
Where is it?
Well, that's what, my lord. In the FDP, I am challenging, my lords. The order that has been passed is in the FDP, my
The
lords.
preliminary decree has also been rectified in view of the subsequent duress.
Yeah, that is what
by this order. By this order.
Yes, my lord. By this amendment, my lords. By allowing this amendment, it was rectified in FDP, and later it was asked to be rectified in OS, my lords.
No, the court is not saying by virtue of this order.
No,
the
my
court
lords.
says it is already done.
No, my lords. The amendment was sought for in FDP, my lords. That was allowed, my lords. Once
Where
FDP,
is the application? Where is the application?
my lords.
Application in sub. Yes.
Amendment application. I'll just read that amendment application.
Where is that?
My lords, what the amendment has sought in FDP 9/23, my lords, IA number 4. That is annexure F, my lords, page number 89, my lords. Your lordship would find that, my lords.
Yes.
The second para, subsequently subjected to duress by the government and renumbered as 281/2, measuring 2 acres 12 guntas, and 282/2, measuring 2 acres 16 guntas, respectively, my lords.
What it says is
My lords.
already in the preliminary decree it is changed.
This what preliminary decree is what I am challenging, my lords. I'm not challenging the voice, my lords. It says, my lord, may I just read the judgment, that one portion, my lords. More so, the preliminary decree has also been rectified in view of the subsequent durasti subjected to the said property. In spite of giving opportunities to the respondent, they have not chosen to file objections, but the same is taken as not filed. For the reasons urged in the application annexed with the affidavit IA is hereby allowed. So this IA is sought for the
You mean to say executing court will amend the preliminary decree?
first it allowed the amendment of preliminary decree, my lord. Then it asked him to.
No, I'm asking the executing court will amend the preliminary decree.
That is what is it has happened here, my lord. Then he was asked to amend even the original suit, my lords. That is what the court did here, my lords. Because the FDP came to be allowed, it needs to be allowed even in the original decree. He was asked to even amend the original decree, my lords. First, it was allowed in this FDP, my lords.
What the court said, please read it. I can read it from only what is stated there.
My lords. Now that the property has been subjected to durasti and renumbered as so and so, the commissioner can carry out the execution work as per the amended preliminary decree, my lords. This the court has come to the conclusion that it has been durasti has been done based on the memo filed by the plaintiff, my lords. But in fact, the very commissioner himself has given the endorsement saying that durasti cannot be done because it has not been, the measurement cannot be done because durasti has not taken place, my lords. This property which is claiming 281 and 282, it's a grant land, my lord. I can furnish before the trial court that is totally a separate property. But just because I was suffering from ortho disease, my lord, I could not attend the court and file my objections. If I'm given an opportunity, I can demonstrate to the court that what he is seeking as the renumbered property is totally a different property from item number 3, my lords. All I am seeking is an opportunity.
What I can understand from this is already the amendment is carried out in the preliminary decree. That is what this. That's why he is permitted to do so. The final decree, I mean, in the final decree proceedings also is permitted to do it. That's what the court says.
Primary decree in the sense in the original judgment, my lords, voice. That is what they say, my lords. But at the first instance, it was not done in voice, my lords. It was done during the pendency of FDP, my lords. During
That's
the pendency.
what, have you questioned that? That is what my question from the beginning.
My lords, sorry, I could not get your lordships, my lords.
Have you questioned that?
No, that is all I am saying is that I may be let this order. I may be given an opportunity to contest my case in FDP, my lord, and demonstrate to the court that his amendment need not be allowed, my lord. I'm just seeking an
notice to the respondents. Petition is permitted to take court hand summons.
My lord, till them let them not precipitate the matter, my lords.
I am not convinced, Mr. Kaul.
A shorter date may be given, my lord. My lord, may I request that notice be served on the trial court advocate, my lords.
That's what I said.
And a shorter date may be given, my lords. A shorter date may be given, my lords.
Second. Yes.
My lords, in this case, my lords, I have challenged the order of KEB, my lords. What has happened is initially the KEB had demarcated a certain portion of the property, my lords. I will take your lordships to the photograph which I have furnished, my lords.
Petitioner, stay all further construction, erection of towers.
Yes, my
laying
lord.
of cables on the petitioner land. Why?
My lords, I would request your lordship to come to Annexure B, my lords, page 10.
Yes.
My lords, there is a photo there, my lords. If your lordship to be seen that is a triangle, my lords. First, originally the proposal was that straight line, my lord, where the KEB intended to put the towers in that straight line, my lords. Because it was passing through a politician's property, then they diverted it and they made it a little bit curved, my lords. Now it has taken the.
Go to the deputy commissioner and file your objections.
My lords, I filed their objection. They said that no, you cannot challenge. Only thing is you are eligible for compensation. What I am saying is that, my lords, beside my property, there is a government land, my lords. They can use that government land as itself, so it will save that money to the exchequer, my lord. There is
why the deputy commissioner cannot decide it? That's what I have decided in the matter.
My lords, the notice.
1 minute.
My lords.
Yes, my lord. I'll get instruction.
Deputy commissioner has to look into it.
Yes, my lord.
Till such time, don't do anything. Where is the order of the deputy commissioner?
Annexure C, my lords. Notice issued to me, my lords.
No, my lord, it is
Then
the
where
notice, my
did
lord, issued by the
you? Then
BESCOM.
any order is passed.
My lords.
Any order is passed.
They are saying that we are encroaching your property and we are giving this X amount as the compensation, my lord. They already come to the conclusion, my lords. Without issuing any note.
If you have objections, there is no question of notice and all in this. If you have objections, you have to go.
I had sent the objections, my lord. They had not taken the register post that was sent, the objections, my lord, that has
When
been
did
sent
you,
to
I'll ask the deputy commissioner to consider. When did you send?
my lord, sir. On 27th, if I remember right, my lord, it has come back saying that insufficient address. In fact, I have given the same address what is available in Annexure C, my lords. Annexure B, my lords.
According to in the insufficient address is refusing to take.
Yes, my lords. It is insufficient address, he says, my lords. I have put the entire address what is given in this letter, my lord. In spite, it has come back saying that.
Go before the authority and let the authority decide it.
They may be given a direction to look into my grievance, my lords, before taking any coercive steps, my lords.
Let Mr. C. Chennegowda is directed to take notice on behalf of respondents of 2 and 3. 1, HCGP takes notice. List this matter on Monday in the first list. Serve papers on him.
Grateful, my lords.
Cell number 20, Girish. HM.
My lordship, the petitioner are the defendants in the before the trial court in OS number so and so, filed by the respondent seeking the relief of declaration and injunction in respect of the suit scheduled property. See, the suit summons was served to the petitioners on 30th 10 2025, where appeared before this honorable court on 17/3/2026. Return statement.
When did you file?
We are filing return statement along with I on 17/3/2026. There is a 19 days delay.
Yes.
There.
Commercial suit or a normal suit?
Normal suit for declaration, voice.
Same, that written statement. When counsel for the petition submits, the written statement is not taken on record. So, yes, stay.
Cell number.
Grateful.
Number 21. Janardhan Ji.
That she is one of the daughters filed a suit for partition against her brothers, and the brothers filed a statement. They have not entered the witness box. Then the buyers of the property have entered the witness box and given the revealed before the court, saying that item number 1, 2, and 3, 4, and 5 are the self-acquired properties of father. Produce the documents. But I have, my daughter married long back and went away from the family. But brothers were managing, and they have, on seeing the documents, I said, I sought for an amendment. Item number 1, 2, 3, and item number 1, 2, 4, and 5 are self-acquired property, not the ancillary property. But the learned judge says that it is a belated stage and you cannot do it. But they
of the year 2013.
Certain, madam. What happened is now the evidence has been given.
You are the plaintiff.
Madam, I am the plaintiff, one of the daughters. But
no, that is taking
No, no,
altogether a different case.
I'm not.
That is taking altogether introducing a new case.
No, madam. What I'm
the original stand.
Marginal stand is I stated my item number, so shoot shell property consisting of 8 items are all ancillary property, as I said, ancestral property. But my brothers, after the death of my father, my brothers used to manage the property, that is defendant number 1 and 3, and they never produced any document before the court except a statement. But the buyers of the property have produced the document before the court. They themselves made a statement that is these items are self-acquired property of my father. But they have produced the document, not exhibits. But I am the most illiterate. My
Every purchaser will say
yes,
that it is a self-acquired property. So
not that.
For partition not possible.
Not that. But here, I stated.
No, basing on a defendant's statement, you say that I have.
No,
I will,
based on that, not on the statement, madam. They have produced. I have produced.
So, by virtue of this amendment, you are taking away an important admission.
They themselves admit in the cross-examination have produced.
That is the purchasers.
But that is purchasers.
Well,
and my brothers also made a
defendants?
statement that item number 4 is the self-acquired property of my father.
Who
and
says?
My brothers. I have filed the written statement also. Kindly come to. And the others are self-acquired.
Then the suit for partition has to be dismissed as far as those properties are concerned.
Right. Suit scheduled properties.
As far as those properties are concerned, it has to be dismissed because it is his self-acquired properties.
But self-acquired properties, I am having, not only thing is difference is this, but if it is an ancillary property, but in view of the fact that section 6 amendment, if it is under the self-acquired of my father,
The sales are before 2004.
Blood, that is sales are 2004 in respect of 2 items, blood. And the other item is concerned, another 4 item is concerned pending proceedings, blood, it has been taken place, and that is why there is no issue about the same. But 2 items, blood, item number 1 and 2 are sold at before cutoff date. But fact remains is all the original documents in the custody of my brother passed on to the buyers, and they have placed before the court. I have stated the exhibit. They themselves has placed before the court. I am not saying anything.
Now your plaint.
Yeah, but the custody of the document with them.
The custody of the
sorry.
document. Your entire pleadings has to go now.
No,
Your
no, madam.
pleadings basing on a property is a joint family property. You filed the suit.
Yes.
No, property is not joint family. It is
Blood,
your spouse's-
only 2 items. Blood. Items only. Not 4th item is the self-acquired property of my father. They themselves admitted my brothers. And the pending proceedings, the transaction taken place.
Please come to your IA.
Yes.
Page number.
Blood, I page. Plaint, blood.
IA in support of.
Yeah, yes. Kindly come to annexure F, blood, page 93.
90?
93. But this is in paragraph 4, second line, delete ancillary properties and replace the same by words among the following properties. Item number 1, 2, 4, and 5 are the self-acquired property of his father, and item number 3 is the self-acquired property of her mother. But among them, item number 5 is already acquired by the government for notification. There are not much consequence, because that is land has been used for formation of the road, and it is not available for partition. Not kindly come to the plaintiff regarding para 6A to C is concerned. These are all the properties that item number 2 regarding pending transaction taken place, and that is what I have explained. And then up to C. But question is para 2 of my affidavit. Kindly see. Para 2. But I state that for the reason that I have married long back and settled in my husband's place after the death of my husband, partition has not been affected. I filed a suit for seeking partition of my share. However, all the document and revenue records in the suit properties were managed by defendant number 1 to 4 on behalf of joint family, and I could not have personally aware of the acquisition of suit properties in detail, except knowing the fact belongs to my father.
So the matrix for final arguments.
Blood?
Final argument.
Now it come to final argument.
Defendant's written statement and evidence is when?
Defendant statement the defend my brothers, 1 and 3 made a statement that item number 4 is the self-acquired property of.
When I'm asking.
I just. They have filed a statement on 11/4/2014. 11/4/2014, they made a statement regarding item number 4 is concerned. Other properties, there is self-acquired properties of them.
When was the statement?
Their statement is on 11/4/2014, their statement, but they have not entered the witness box. But the buyers have entered the witness box.
When?
That is only on, yeah, I produced the deposition also before the court. It is on examination chief on, but artist, date is not there, I'll give 1 minute. But I have cross-examination, I have done it on 2/6/26. And earlier to that 1 week, I think, because the affidavit date is not there, it is earlier to that 1 month, and I'll give 1 minute. DW1.
Documents are filed when? Documents are filed when?
But only that cross-exam before 1 day earlier to cross-exam. But kindly come to I have produced the evidence of the parties also. But the one of the he has filed it on 25th March 2026. But at page E1, page 90.
In counsel for the petitioner submits originally Suit number 2 and 4 scheduled properties are according to the plaintiff or the joint family properties. The defendant number 1 and 2, the family members and the purchasers have taken a stand and produced a document before the court to show that it is a self-acquired property of the father. Concerning the documents which are placed before the court during the cross-examination of the purchasers, petitioner has come to know about that fact. Hence,
The
they have filed
examination
a-
chief, you not please. The examination chief and cross-examination.
Cross-examination. Hence, they have come up with an application seeking amendment of the plaint. When that is a consistent case of all the parties, there is no reason for the court to deny the same, and no prejudice would be caused to the defendants. All these aspects were not considered by the court considering the same. They shall be stay upon further proceeding. Notice and so.
Stay for limited period. Stay for limited.
Bill number 22, Desai Raj.
Yes.
Not appearing for petition.
Yes.
My lord, here, my lord, the suit is for partition and a separate possession, my lord. My lord,
Mike Termatil.
my lord, the petitioner has instituted a OS number in 306321, my lord, for the seeking partition.
What are you questioning? What is the order?
My lord, annexure D, my lord. Annexure A, my lord. Passed in FTP 144, my lord.
Office is directed to draw final decree.
Yes, my lord. My lord, here, my lord, the court commissioner was appointed, my lord, and then, my lord, the court commissioner was issued a report, my lord.
Final decree proceedings are allowed.
Yes,
Oh.
my lord, here, my lord, the problem is, my lord, the property which was allotted for the petitioner, my lord, it is the northern side of the property, my lord, and my lord, the home situated at the northern side, southern side, my lord. So, my lord,
No, how can you file a writ petition? No, the final decree proceedings are concluded by virtue of this order.
my lord, still the final decree has not drawn, my lord.
Yes. Yes.
And, my lord, the defendant therein, my lord, filed an application, my lord, for the court commissioner, my lord, and we have filed an objection, my lord, for the court
What are your objections?
my lord,
What are your objections?
my lord, stating, my lord, the share which have allotted for me is an arbitrary. So, my lord, the court commissioner report has to be not imposed, my lord. So, my lord, and thereafter, my lord, on that basis only the honorable court has passed in a preliminary order, my lord.
Para 16, come to para 16.
Yes.
According to you, what is the incorrect distribution?
My lord, the allotted share for me was, my lord, in
That
the
is
US.
as per the preliminary decree. It is
Yes.
to the 200, over you 262.50 square
Yes,
feet.
And, my lord, the allotted was 275.60, my lord.
Allotted was?
275.60 square feet, my lord.
You are?
My lord,
You are the?
for petition.
No, petition is the plaintiff or the defendant?
In the US plaintiff, my lord.
Preliminary
The
decree
FD?
allotted 262.50 square feet.
Yes.
Now, according to you, they have allotted more than your share.
Yes, my lord. My lord, here, my lord, I have constructed a home, my lord, in the northern side, my lord, southern side, my lord, and they have allotted me for the northern side, my lord.
Where are your objections? Let's see.
My lord, I have not annexed, my lord, kindly, my lord. I have not annexed with this, my lord, objection. Kindly one short it.
This is matter on 3rd of September.
Much of.
So number 23. 23 Gurudat BS.
1 week time, my lord, because I need some document. 1 week time may be granted.
It's 2 weeks. 24.
Cell number 24.
My lords, for the petitioner,
TN.
my lords, I'm challenging an order of amendment, my lords. By way of which, my lords, the trial court has allowed the plaintiff to change the survey number and an extent of the property, my lords. A completely different property is sought to be included in a suit for partition.
Suit is of which year?
Suit is of the year 2018.
Come to the order.
My lords, order is Annexure A. My lords, reasoning starts, my lords, at page 30.
Who are you?
My lords, I am the defendant number 7 and 8 before the trial court.
You are the family member or a purchaser?
My lords, I am a family member. I was initially, when the suit was filed, I was not arrayed as a party. My lords, to give a brief background, 2003, my lords, there was one suit which was filed, my lords, for partition. There my father was arrayed as a defendant, my lords. In the initial suit, my lords, item number 5 was denoted as survey number 23/2, and it was an extent of 4 acre 5 guntas, my lords. That suit comes to be dismissed for non-prosecution, my lords. Subsequently, miscellaneous petition is filed. That miscellaneous petition is also dismissed in the year 2013 for non-prosecution. 2018, my lords, there's a suit filed for partition. In that partition suit, my father is not arrayed as a party. I come to be impleaded in the year 2024 by way of an order dated 11/11/2024, my lords. In that 11/11/2024 order also, item number 5 is denoted as survey number 23/2. Subsequently, my lords, what happens is 19/8/2025. There's an injunction order, my lords, which is passed, restraining the defendant from alienating the suit scheduled properties. That injunction order was maintainable for a period of 3 months, my lords. Subsequently, what happens on 25/11/2025, 2 applications are filed. One application for amendment, second application is filed seeking to extend the interim order which was lapsed. And by way of an amendment, my lords, he is saying that item number 5 was never 23/2, it was 28/2. And he asks the court to extend, basically the extent of the land is also increased, my lords.
What is the prejudice caused to you by this?
My lords, now, my lords, there was a partition in the year 1993. Partition is between, there are 2 branches, my lords. My lords, I would just like to produce a family tree just for the ease of this honorable court's reference.
What is the stage now?
My lords, now the stage is for plaintiff's evidence, my lords. The matter gets
evidence is not started.
My lords, not started. The plaintiff has remained absent for 2 occasions. On 19/8/2020.
No, what you have to tell the court is what is the prejudice by? It's a suit for partition.
Please.
Is it your case that you are in occupation of that?
Please, my lords, it is my independent property.
What is the extent of the property?
My lords, 6 acre 22 guntas, my lords.
What was shown earlier?
My lords, earlier it was shown as 4 acre 5 guntas.
Item number 5. 6 acres and odd.
Please. My lords, earlier it was 4.5 acres. My lords, there was.
This entire one is one piece of land.
My lords, my lords, I didn't.
The entire 6 acres is one bit of land by one document.
My lords, entire extent is 6 acres 22 guntas. It came to me by way of partition. My father got 4 acre 27 guntas of land.
By changing this, by amending this, what is the prejudice to you? That I'm not able to understand.
My lords, it was never the joint family property.
Either it is 4 acres is also not.
No.
So either it is 4 acres or 6 acres, it is for him to prove.
My lords, my submission is that my lords may kindly look into the amendment which is sought. It's at Annexure B, my lords.
It's a typographical mistake and they want to change it.
My lords, even in the first suit, my lords, my submission is that suit was first filed in the year 2003.
Let us assume that even in the first suit also it is stated. Now, what is the prejudice to you?
My lords, there is
either it is 4 acres or 6 acres. According to you, it is not a joint family property. It fell to your share by way of earlier partition. No, you will take the same stand.
My lords, now what happens?
Document is pertaining the entire property is 6 acres. Please. It is an admitted fact. According to you, it is there.
Please, my lords, it is there. Now, my lords, what is the prejudice that is being caused to me is, my lords, as of today, there is no injunction, my lords, which is operating against me. 19/8/2025, when the injunction order was granted for 3 months, there was no order which was restraining me from developing the scheduled property, my lords. Now, my lords, by way of an amendment, he seeks to include the property which was never there in the suit originally. And on the same day, my lords, they are filing an IA to extend the order which was elapsed. No, my lords, he is trying to do something illegally which was otherwise never granted by the trial court. Trial court did not grant an injunction order restraining me.
Now, by virtue of this, court has permitted him to amend the plaint or also granted injunction.
My lords, it has permitted him to amend the plaint, my lords. Now, there is an order of injunction. My lords, if that order gets extended, now, my lords, that injunction order will also start operating with respect to my property. My property was never included. My lords, 1993, my lords, partition deed. By way of partition,
I understood your submission.
please. My lords, both survey number and extent, my lords, is changed. It is not only the survey number, my lords. Survey number, my lords, if it was 4.5, 4 acres, 5 guntas, and it was changed to 4 acres, 5 guntas and different survey number, it is
very simple. According to you, a particular property is allotted to you in the partition.
Please.
He says it is a joint family property. Now, in the partition, it is allotted to you is 6 acres.
Please.
He has mentioned it as 4 acres earlier. Now he wants to show it as 6 acres. It's the only difference. Even according to you, that 4 acres also is not the joint family property. It is your property fell to your share. So, what is that prejudice? I am not able to understand.
Well, now he is introducing a company.
Your only apprehension is now this injunction will also extend to the 2 acres.
Please, my lords. No, it will extend to the entire 6.27 acres because that property was
4
never
acres
there.
it is there.
No, my lords, it was not there. My lords, it is a completely different survey number.
No.
My lords, may kindly look into plain schedule.
I understood. It's a case for dismissal. If you want, I can only give notice. I'll not pass an interim order. Notice to the respondent.
Notice, please.
Number
Petition is
25.
permitted, take out handsomely.
Please, my lords.
Judges. 25.
I am for petition. This is the proposed defendant petition, Your Lordship. The defendant number 2 before the trial court has filed the application under order 1 rule 10 and implead the petitioner as the proposed defendant number 3. I am for proposed defendant.
You are the proposed defendant.
Yes, Your.
You are against that allowing that order.
Yes, Your.
Come to the order.
Your Lordship, kindly see the internal page number 17, the annexure A, Your Lordship.
Come to the reasoning part.
The 17 internal page number, the para number 13, may I read, Your Lordship? From the contention of the defendant number 2 in IA and from the plaintiff government, it's forthcoming that there is an involvement of proposed defendant number 3 in the present dispute with respect to suit.
Your defendant number?
I am proposed defendant number.
Proposed defendant.
Your Lordship, kindly see the plaint in the plaint prayer, which is in internal page number 22.
Prayer is there at para number 9.
Your Lordship?
Para number 9 of the impugned order also prayer is there.
Yes, prayer is there. And the issues is also framed by the trial court. There was no prayer against these proposed defendant. And this application filed against the will and wishes of the plaintiff. The plaintiff is sought for mandatory injunction in the nature of not to hand over the certain document, original document in favor of the defendant number 2. The bank is the defendant number 1.
Please read the order, then I'll hear the.
Your Lordship, kindly see that page number 13, page number 17, para number 13. From the contention of the defendant number 2 in IA and from the plaintiff government, it is forthcoming that there is an involvement of proposed defendant number 3 in the present dispute with respect to the suit of property. In order to elicit the truth and adjudicating this list completely is presence is necessary before this court. Under order so and so, it is contemplated that proviso for striking off or impeding the parties during the pendency of the suit as per the facts and circumstances of the case. Here in case if proposed defendant number 3 is not impleaded in the case, same would lead technically which would lead to further multiplicity of proceedings. Here it is a clear forthcoming that proposed defendant number 3 have also active role in executing the sale deed in favor of the plaintiff with respect to the suit of property. And as the execution of the sale deed is disputed by the defendant number 2. In presence of the proposed defendant number 3 necessary for proper adjudication. The suit is not for the validity of the sale deed or whether.
And counsel, the petitioner submits that. At the behest, the defendant number 2 has filed an application under order 1 rule 10 to impeach the petitioner, who is the husband of the plaintiff. The plaintiff has filed a suit for injunction. and,
Mandatory injunction.
Mandatory injunction. And the defendant's presence, the proposed applicant, that is the petitioner's presence, is not necessary for adjudication of the dispute between the parties. Without considering all these aspects, court has allowed the application. Considering the sufficient, there shall be operation of stay of operation of the order impugned. Notice to the
Great.
respondent.
Cell number
And
26,
summons.
M. Srinivas Reddy.
Petitioner wives. We challenge the order passed by the trial court regarding the amendment application. We sought for
What is
addition
this-
of
what is
new
the
survey
suit for?
numbers as per 4D was conducted recently. That's why we sought for
Let's see the IA.
in page number G 102.
Or not?
102 arts
102 is the order.
house.
I'm asking where is the affidavit?
You kindly say. We have stated in my affidavit, my lord, you kindly say. Grounds, kindly say, in page number 8, my lord. In page number 8, there are the partition suit filed by the sister of the defendant number 1, my lord, para 12 in the petitioner submits the suit filed by the petitioner for partition separate position sought for one to share among the suit scheduled properties. Suit scheduled properties are the joint family property. There was no division among the plaintiff, petitioner and respondent. The relationship is admitted and the suit schedule belong to the joint family. The petitioner submits that recently came to know that some of the suit schedule are given to survey numbers, new survey numbers and boundaries due to the POD conducted by the revenue authorities. This came to know the petitioner after obtaining the revenue documents. Due to that, petitioner filed application sought for amendment of the plain items mentioned new survey number in place of old survey numbers. Only that's much, my lord, and now the matter was yet to commence trial, my lord.
Where is the POD?
POD was kindly to that effect, my lord. I produced the documents regarding the RTCs, my lord, kindly say in page number 110, Annexure H, Annex 109 in the
When it was done?
110 in the
It was done on?
sub numbers was given, my lord. That's
When?
110, page number 110.
No, I've
Annexures.
seen it. I'm asking the year. That is what the court has observed. Suit is decreed, appeal is filed, appeal is remanded. After the remand, you will amend the petition.
After remanding the matter.
No, you have already amended once. This is the second time.
You sought for only the insertion of the new survey numbers, my
The
lord.
court says that's what. Where is the material? When was the POD changed? What has happened?
I will
You don't
produce,
file
my lord.
anything.
RTC was produced, my lord, to that effect, my
Well,
lord.
how will we understand when was it? How was it?
I will get it.
Notice and summons. Yes, next.
Cell number 27, Ganesham. 27, Ganesham.
No representation, September.
Cell number 28, Ramesh VK.
In this case, Lord, suit for the injunction agreed by the IA order, IA filed by the defendant to appointment to the court commissioner to conduct the survey of the
What is the
site.
suit for?
Injunction.
What is the stage?
Now it is for defendant evidence, my lord. Instead of conducting defendant evidence.
Come to the order.
Lord. Lord, they filed an application on Article 26, Rule 9, 1 CPC to appoint a government surveyor as a court commissioner to conduct inspection of the suitable property, to identify and support whether the suitable property is situated at survey number 51 or 52/2. But here the nature of the suit is not a survey number, my lord. In 1992 itself, the sites are formed and the petitioner herein are in a possession from 1992. It's not like now in the application, they thought, but in the order, the court said it's only for a local commissioner to conduct the local survey. But in this application itself, may I read the application, my lord? May I read the application, my lord? Page number 22, annexure B. It's the very clearly they stated that the shoot shed, in that to appoint a government surveyor as court commissioner.
Whatever is the report of the survey.
No, my lord. It is only to harass the petitioner this application of filing because they are not produced any document before the lower court. This social property belong to the defendant. We are the petitioner is in the possession till from 1992.
No, it is good for you if the survey is done. You are the plaintiff.
No, my lord. It application filed by defendant. I am the plaintiff.
Whoever has filed the application, ultimately the survey will be done about with regard to the suit schedule properties.
No, my lord. We are in a position. The survey number nature is not at all. It's gone in 1992
If you are in
itself.
possession of the property, it's good for you. The surveyor will give the same report.
No, my lord. In the application affidavit itself is stated that in the I'll read page number 23, my lord. It's only to harass the petitioner and to grab the property. Only defendant is doing these things because he filed his written statement after 3+ years. He's not filed anything. No document is filed, my lord.
With the orders passed in.
Lord, with request, I read the page number. Is on affidavit, my lord. In the last pages, only one
Harassment by your contention that he filed the application to harass you can't be a ground.
No,
What
my
is
lord,
not-
no, that's a one of the ground, madam.
What is the other ground?
Second ground, I'll read his own affidavit, my lord, in page number 23. He seek for the whether it is belong to 52 or 53. But in his own affidavit, he stated that the suit scheduled property is not situated in survey number 52/2, and even it is no way concerned to survey number 52/2 of the Karivobnalli village. His own affidavit is said that, but he is seeking the application to survey the court commissioner only to identify and collect the information because he is not produced any document to show that this future properties belong to him. No, sir, no evidence is there, and he has not produced any document at all. He is not doing the evidence also.
What is the present stage?
It is different evidence, my lord. And even twice he reopened for the cross-section of BW1. Matter is reached for arguments. Then he recalled application, but he's not done a cross-examination. It is closed. Then it is stated for the defendant evidence. He's not deleting the evidence, but he's now filed this application to court commissioner only to collect the evidence. It is not that because he is in affidavit itself is stated that in the application he said to identify the survey number, the social property belong to which survey number. But there is no affidavit is saying that.
What is your case?
My lord?
What is the case of the plaintiff?
Plaintiff is we are in a possession, my lord.
About the survey numbers.
We belong to survey number of 51. It is already 1992. The layout is formed that we belong to 51. And he is in his own affidavit is stating here in the last paragraph, page number 23. Scheduled property is not situated in 15. He is saying that 52/2 is his land and his property one side he is saying. He is saying that whether it is belong to 51 or 52, we want to identify through court commission as a government surveyor is wants.
Yes.
But that he is not produced any document to show that this suitable property belongs to him.
Please come. The present agreed with the order passed by the court on an application under Order 6, Rule 9 for appointment of the Advocate Commissioner dated 8 January 2026, notice number 862 of 2020 by the Second Additional Civil Judge Bangalore. The petitioner, defendant is the petitioner, plaintiff is before this court. The petitioner has filed a suit for injunction. Well, the matter is coming up for the defendant's evidence. The defendant has filed the present application under Order 26 Rule 9, praying the court to appoint a court government surveyor as court commissioner to conduct local inspection and inspection of the suit scheduled property and to submit the report before the court. That is opposed by the defendant, stating that only to harass the petitioner the present application is filed, and also the application is filed to that this is nothing but amounting to collection of evidence. The defendant is not proceeding with the defendant is not proceeding with the trial. and proceeding with the trial and without placing any document on record. The defendant cannot ask for the appointment of the commissioner to collect the evidence. The court by order impugned dismissed the application. While dismissing the application, the court has observed that the contention of the plaintiff that the defendant application is finally only to delay the proceedings cannot be accepted at this stage because the dispute regarding survey number and identity of the property goes to the root of the matter. Further appointment of commissioner for identification measurement of the property would not amount to collection of evidence since the commissioner is only expected to note down the physical features and conduct survey with reference to official record. It's the court of the considered opinion that appointment of a qualified government surveyor as court commissioner is necessary for proper adjudication of the matter, and the same would also avoid multiplicity of proceedings in future. No prejudice would be caused to the plaintiff. Local inspection is conducted in the presence of both the parties. Agreed, the Land Council appearing for the petition has argued in tune with the submissions and objections that are filed before the court, and it is submitted that the court cannot appoint an advocate commissioner. Next para. Having heard the Land Council of the petitioner, there is a material on record. The petitioner has sought for an injunction. Now the court has both the petitioner and the plaintiff and the defendant have taken different contentions with regard to the identity of the property. Now the court has appointed the surveyor to survey the land. If once a report is placed before the court, it is for the court either to accept the same or reject the same. The court rightly observed that it does not amount to collection of evidence. The defendant not proceeding with the trial or defendant taking a different stand. All these are matter of all those issues cannot be the ground to reject this application. In the considered opinion of the court has rightly passed an order and it requires no interference. Yes.
Cell number 29, Mohan Chandraki.
What order? 30.
My lord, dependent restriction, my lord. The trial court allowed IA number 2 and given police protection to the plaintiff to implement order passed on IA number 1 and 3. The suit is one for permanent injunction filed by the plaintiff. Along with the plaintiff has filed IA for temporary injunction not to destroy the maize crop standing in the suit scheduled property. Trial court granted expert order of injunction. And thereafter, the plaintiff files application IA for police aid on 2/12/2025 to implement the order on IA number 1. In the affidavit, it is clearly mentioned that not to interfere with the suit schedule. There is no order passed by the trial court regarding not to interfere with the suit scheduled property. Thereafter,
what is the injunction then?
Injunction only not to destroy the maize crop, not to damage or destroy the maize crop. Thereafter, application filed IA number 2 for implement to give police protection. Thereafter, he files IA number 3 for not to interfere with the suit scheduled property. After then, I filed objection to both the IA. After lapse of 7 months, the trial court allowed both IA 1 and 3, and granted temporary injunction. Thereafter, I allowed IA number 2 and given police protection to implement the order passed on IA number 1 and 3 retrospective effect. Because at the IA number 2,
which order you are questioning now?
IA number 2 regarding
order.
Your lordship kindly see page number 63, relevant portion 64, page number reason. May I read?
1 minute.
The temporary injunction granted by 64 page number. The second para, the temporary injunction granted by this court continues to remain in force. There is nothing on record so that the.
Where are you reading? 60?
64.
Where?
Second para.
It starts with the objections raised by the.
Not object 64 page number.
Second para is the objections raised by the defendant regarding title and possession.
Maybe 63. My page 64.
Huh?
64, 63 maybe. The temporary injunction granted.
That
by-
is 63.
Granted by this court continues to remain in force. There is nothing on record to show that the said order has been vacated, modified or stayed by any superior court. Therefore, so long as the injunction order remains operative, every party to the proceeding is bound to obey and honor the same. Magistrate judicial orders cannot be permitted to be undone by disobedience or deliberate violation. The inherent powers preserved under Section 151 CPC empower the civil court to pass such order as may be necessary for the ends of justice or to prevent abuse of process of court. It is well settled that where a lawful order of temporary injunction is likely to be defeated on account of a deliberate act of opposite party, the court is competent to direct a police assistance for effective implementation of its order. Police aid is not granted to create any new right in favor of the party, but only to ensure due enforcement of existing judicial order and to maintain the rule of law. The objection raised by the defendant regarding title and possession cannot be gone into while considering the present application. Those questions are matters to be adjudicated during trial. The only
Where
question
is the order of injunction?
injunction page number annexure E, page number 49. Order I number 1 and 3 filed by plaintiff under order 39 rule 1 and 2 read with section 150.
Party temporary injunction granted against the defendant, restraining him from destroying the maize crop grown in the sue scheduled property till the next date of hearing.
Yes, I number 1. I number 3, thereafter, after filing I number 2 for police aid, I number 3 is filed not to interfere with the suit schedule.
Where is that order?
Same way, page number 47, annexure E.
This order is passed when?
Passed on
20th July.
20th July.
2026.
Yes. I number 2 was allowed on 25/7/2026.
Have you questioned this order?
Yes, prepared appeal before the appellate court.
What happened to that?
Because caveat is filed, still pending. Because the IA is filed before filing IA number 3. IA number 2 is filed on.
You have to seek any order before that court, any interim order.
Because on the
fact remains is there is an injunction. It is not stayed by any other court. And if for implementation, whatever has to be done has to be done.
At the time of passing IA, because the initial court.
I understand.
Initial
but
court.
But this order is not before the court. This order dated. Where is that? You said it is 2/6/2026. This order is not before the court.
27/2026.
So, all these submissions.
No, I have produced 27 to
not before this court means not impugned before this court.
Yes.
That is before the appellate court.
Yes.
There you have to go raise all the, unless and until that order is, any interim order is granted, as long as that order is staring at you, you have to comply with it.
Yeah, my contention that before passing the order, IA is filed for police protection. No order is at the time of filing IA number 2, there is no application or no order is passed by trial court. IA number 3 is filed.
Come to that application in this IA number 2.
IA number 2 is filed on page number 21. Annexure C, my lord.
This is filed when?
On 2/12/25.
When was the first order of stay granted?
First granted on 28/10/2025, not to destroy maize crop. But this application filed not to interfere.
I am not asking about this. I am asking about this police protection. 150.
Oh, police protection was filed on 2/12.
Where is that order? That IA?
I is produced annexure C. Para 2 of the affidavit clearly mentioned not to interfere.
Please come. Then counsel the petitioner submits that initially an order of injunction is granted on 28/10/2025, restraining the defendants from damaging the maize crop. Thereafter, another IA is filed seeking an injunction. Where is that second order?
27/1/2026.
Where do you get that? No. Another IA is filed.
Page number 29.
29. Not 29.
27. Your Lordship, kindly see page number 55, order sheet. 27/1/2026 mentioned clear. Learned counsel for plaintiff files I application under order 13 rule 1 and 2 CPC, and same is hereby numbered I number 3.
Then files I number 3 order, where is it?
Same I number 1 and 3 is clubbed together, pass one order.
But it also says about not causing damage to the maize crop.
I number 1 pertaining not to cause damage to the crop. I number 3 regarding interference, separate I.
The I number, then I number 3 is filed and an order is passed on 20th July 2026. An application that is filed on 2/12/2025 seeking police protection. On that, the court has passed an order directing the stationer's officer to extend necessary police protection. Then counsel submits that as on the day when the application is filed, no order has been passed. And basing on the said order, the present order is passed by the court. Considering the submission, it shall be stay of all further proceedings. Pursuant to the order dated.
Much okay.
Cell number 30, Mahesh Kiran Shetty.
Lords, the excise license stood in the name of Krishna Reddy.
Yes.
Krishna Reddy dies. Krishna Reddy has only a widow by name Premamma. The excise license is transferred in the name of Premamma. Premamma also dies, not leaving behind any children. No class 1 heirs is left behind. So now, the property has to go back to the heirs of the husband. That is the law. Now, the legal representatives of the husband file an application seeking transfer by producing the documents to show that number one, they are the legal representatives, and the person who makes an application has a no objection from all the heirs that he can make an application seeking transfer of the excise license. For that, an endorsement is issued saying that no, you have to obtain a succession certificate. Then the matter came up before this Honorable Court. This Honorable Court observed that the procedure as contemplated under Rule 17A has to be followed. A mandamus contrary to 17A cannot be granted. Therefore, they were directed to consider the same within a period of 2 days. Lords, now they have considered this in two fashions. Lords, may kindly have a look at. Lords, I'm just passing on the translated copies, Lords, for Lordship's consideration. Copy.
Yes.
Lords, 23/7/2026 at page number 62 in the papers which I have now given, my lords. Lords, your lordships passed the orders on 21st of July 2026.
Yes.
Just some dates may be necessary, my lords. And a notice is issued to me on 23/7/26 to appear for an inquiry, which your lordships will find, my lords, at page number 60 in the papers which I have now handed it over.
Yes. Yes.
So I was required to appear for a hearing which was issued on 27/3/2026.
Yes.
Lords, the date is on 24/7/26 at 12 noon. Lordship gets it, Lords.
Yes.
Now what they do is, page number 62, an endorsement is issued. Notice, I'll just take your lordships to the English version of it at page 64.
Yes.
Paragraph number 2, they say that since you have not provided a succession certificate from the court stating that they are heirs of the deceased license holder and they do not have direct heirs, since the said license holder has died and the license held by him has not been transferred to the legal heirs under Rule 17 of the license, since excise year has come into effect, notification reference number 2 as the year commencing 1st July, ending 30th July next calendar, since the excise year of 25-26 has ended, it's not clear who are the direct heirs of the deceased. Legal heirs are pending completion of 17-year proceedings. Your appeal is hereby disposed of. Notice now the proceedings is already closed on 23/7/2026 when a notice was issued to me to appear before the authorities on 24/7/2026. That's what they do. Nonetheless, what they do is again at page number 66, at page 68, the hearing notice, and page number 73, 2 more notices are issued, saying that we are holding an inquiry. Notice now an order is passed. Lords may kindly take notes at page number 94. The order commences, the English translated copy notes commences from page number 82 at page 94.
Yes.
Lords, last paragraph in page 95. Hari Prasad, Gopal Reddy, Ashwath Naran Reddy have filed a dispute application claiming to be the heirs of deceased license holder and have separately obtained the pedigree certificate from Revenue Department submitted to the office. However, it has been found that 2 different persons related to the same deceased license holder, Premamma, have obtained separate pedigree certificates from the Revenue Department claiming to be the heirs. Who are the heirs as per 17A of the General Excise Rules? It is not possible to determine from the documents submitted in the office. It's difficult to determine who are the heirs, and therefore this matter is cause of legal confusion in transfer of license. Since the documents regarding the legal heirs of the said license has not been produced till now, it is not possible to carry out the process of transfer of license under 17A of the Excise Rules. Therefore, it is ordered that late Premamma and corresponding RBB license so and so for the year 25-26, the liquor stock and the beer held under so and so corresponding RBB license shall be taken into custody by the department and disposed of in accordance with the rules. This is one of the apprehensions which we had expressed, when the matter comes up on an earlier occasion. What they have now done is there is an amendment which they have made, which says, in the event any license, excise license is not transferred or the renewal is not sought for, they will appropriate the license to themselves and put it into the basket for auctioning. Now, here is a case where this license, we have made an application. Application is made by the heirs of the husband. The powers are conferred very deliberately. I just wanted, if this is an analogy which is to be adopted in respect of every proceedings. Now, trade license is already transferred in my name. The authorities under the BBMP Act also have the same power so far as trade license is concerned. Whoever are the legal heirs, they will have to find, and then they will have to do that. Your lordships will find the trade license having been transferred as Annexure L. Which your lordships will find at page number 59. Translated copies. I'm sorry, my lords. I'm referring to the translated copies version. Lords, page 59 in the writ petition papers. It's in English, my lords, so they have not produced that. Page 59.
Yes.
The trade license of this premise has already been transferred in my name, Hari Prasad BG, who is the petitioner. Lords, now a very important question which comes about, my lords. I have to bring it to your lordships' notice that the direction to consider, my lords, the matter was taken up to the division bench. Matter came up on 28/7/2026. The division bench said, are you doing the same thing with reference to every license? You are not doing it. Several cases have come before me where you are taking an indemnity bond and then renewing the license. Why it cannot be done in this case? Please ascertain and then get back. This is essentially the oral direction which was given by the division bench. Matter stood adjourned saying that whatever is the stocks, I am at liberty to see whether I can negotiate with the other license holders and then do this. This is essentially the order which was passed. Now the order is passed saying that my excise license itself will be forfeited to the government. Lords, your Lords may consider as to whether the procedure, Lords may kindly have a look at Rule 17A, my Lords.
Yes.
Because if your Lords were to see, there are such and similar provisions in almost every statute. Lords, let us assume, my Lords, that there is a khata which is standing in my name with any local authority records. Let's an officer of the rank of a revenue inspector, he will change, taking into account that I am the legal heir. Let us assume, my Lords, a Karnataka Land Revenue Act, that's the Land Revenue Proceedings.
Says that.
Excise Act, my Lords, may just Rule 17A of the General Condition Rules 1967. There's a reason why the power is vested in an officer of such rank. Lords, now I just wanted to say this, my Lords. Now, if in respect of an agricultural property, then we make an application saying that so and so has died, therefore an inheritance khata is required to be made out. A Tahsildar will make the khata, and up to the Deputy Commissioner, the power is conferred to find out in whose name the khata is required to be made out. And they will be entitled to find out who is the heir, who is not the heir. Only in respect of very complex civil disputes, they will be referring the matter to the civil courts. Page 17A, in the event of death of the licensee or the lessee on or after 1/1/2000, the Deputy Commissioner may, on an application by the legal heir of the deceased with the previous sanction of the Excise Commissioner, transfer the license or the lease as the case may be in their favor. Provided that the legal heir of the deceased licensee, the guardian legal heir, shall inform the Deputy Commissioner Excise about the death of the licensee within 45 days from the date of death, failing which authority granting license shall have the discretion to cancel the license or impose fine. Provided further that the licensee shall not be cancelled or no such fine shall be levied unless opportunity of being heard is given to the legal heir of the deceased licensee or the guardian of the legal heir. But the only requirement is whether I am a legal heir or not. To apply the law of the land, Lords, the facts which is not in dispute is that Krishna Reddy originally held the license. Excise Department is aware of it because the license was transferred in the name of Premamma, his widow, upon the death of Krishna Reddy. We have produced documents to show that we are the heirs of the. Notice, in such circumstances, what is required to be done by them is they will have to transfer the license. Now, they cannot say that I will create a dispute, because what they are trying to do is they say that the objections raised by the heirs of the widow, that is Premamma, is rejected. For me, they say you don't produce a succession certificate, therefore your claim is also rejected and we forfeit the license. It can't happen both the ways. The moment they reject their claim, somebody should be the legal heir. If there was a direction to consider who is the legal heir, they have to say you are the legal heir or somebody else is the legal heir. They cannot say that I am not sure who is the legal heir, therefore I'll forfeit the license to myself. This is essentially the order, my Lords. Now, immediately I will not say, because the Lordships had earlier directed only that operative portion, because they will forfeit this license and then put it for the auction basket. So only that operative portion I am requesting for the stay, my Lords.
May I please, my Lords? My Lords, the other day, if you remember, my Lords, in writ petition number 23621, bar 26, Ashwath Narayan Reddy also came before this honorable court, approaching directing mandamus to give a representation, my Lords. Even that proceedings will be held shortly. Even they will be called for evidence in that.
Then
All
why
this,
are you,
Once
why are
decision
you,
is taken, where is duplication?
then why did you pass this order?
my Lords, there was a direction from this
Pass an
honorable
order on
court.
20
There was a,
Please understand. You call him, you issue a notice him or notice on 23rd.
please, please.
23rd itself, you will pass an order.
No,
What
no,
is
no.
that?
That was with reference to he made a representation on 15th, my Lord. 15th. This was in reply to that. Annexure, yes, my Lord. Kindly see.
No, is that person made a party to this writ petition?
No, my Lords.
Lords, their claim is rejected.
And P&S is still pending, my Lords. P&S is not 6.
My Lords, I am
And
asking
he's
this
implicated
question to
himself.
myself, my Lords. Are they insisting for a succession certificate in every matter? Lords, in selectively some cases, why are they insisting for succession certificate? Let them place on record by means of an affidavit in respect of how many excise licenses they are asked for succession certificates.
Yes.
My Lord, it will amount to sale of illegal liquor, my Lords, if that is not done so. That is to be understood. Kindly come to annexure, yes, my Lords. Page number 80 of the writ petition, my Lords. This honorable court passed an order on 21/7/2026, my Lords.
Correct.
The representation was given by the petitioner here on 15/7, that is prior passing to the judgment, my Lords. To that representation, the reply was given on 23rd. It is not so for.
No.
Yes,
There is some mistake.
ಅಲ್ಲ ಉಲ್ಲೇಖ ಅಂತ ಇದೆ ನೋಡಿ ಮನವಿ ದಿನಾಂಕ ಉಲ್ಲೇಖದಲ್ಲಿದೆ ನೋಡಿ.
In the endorsement, it is there, my Lords. Lords, the endorsement itself very clearly says, which has been now issued, says, Nimma Manavi Patra Dinanka 15/7/26, which is prior to the disposal of your Lordship's writ petition. Your Lordship said you consider this representation. Now, pursuant to your Lordship's order, they issue a notice to attend an inquiry on 24/7. And they pass an endorsement on 23/7.
That's the year matters here, 15/7/2026 and 14/10/2025.
You mean to say notice is pursuant to the order of the court?
Yes.
And this order is pursuant to a representation. What is the distinction? I'm not able to understand.
Some places they will have to say they are wrong, my lords. It's not necessary to defend every act.
My lords, even the, there's a question of fact, disputed fact here, my lords, as to who's the legal head.
Different aspect. No, we'll understand it. There are two orders. One is on 23/7/2026. There is an endorsement. On 23/7/2026 itself, there is a show cause notice. What
Please.
does both mean? That I'm not able to understand.
My lords,
That's what I'm
annexure, yes,
asking.
my lords, you're referring to, that is passed with reference to 15/7/2026. He gave a representation to that, my lord, before passing the judgment of this honorable court.
Then what is the show cause notice?
Show cause notice is
It's also dated?
23.
What it says? Where is the show cause notice?
Same officer.
It is on 24/7/2026.
Please.
This is in reference to what you have issued this notice of hearing. Where did you say so?
Annexure is Ullekha Nimma Manavi Dinanka 15/7/2026. The translated copy. It is
I'm looking at the translated copy at page 68.
63 minutes.
It has no reference. It has no reference to the High Court order. It has no reference to anything.
Well, but here we have made it, my lords.
The same
Proceedings.
officer from the same office. No, it is like this endorsement is like an order
Yes.
on 23rd. Then again another notice on 24th. Again another order now impugned.
Can
There
I,
should be some consistency in what they do.
can we rehold the inquiry, my lords? That is all my members.
Why the court has no work to every day one writ petition?
No,
filed
sorry
like
for that. This is some mistake, my lord. That is. Leave it there.
Then you want me to set aside this order and again consider both the cases.
Combine both the cases, my lord. With respect to Ashwath Narayan Reddy in writ petition number so and so, this petition. Let them all be present together, my lords.
I'll just. Lords,
Let there be a detailed inquiry, my lords.
Factually, again, my learned friend may not be right. Lords, may kindly see the order impugned. Notice was given to all the three of us. Lords, may kindly see the preamble to the order. At commencing from page number 82, my lords.
We'll set aside this order. We'll
Reference
ask him.
numbers 1, 2, 3, 4. In that 2 and 3, 2 is Ashwath Narayan's application dated so and so. And he is issued with the notice. There is a reference that he has been issued with the notice. Notes page number 88. Last paragraph. Hari Prasad, son of so and so, is present. He files an affidavit under Rule 7.
And why is he not a necessary party to this?
Lords, his claim is rejected. I can understand if his claim is accepted.
What about your claim? Your claim is also rejected.
Lords, my claim is not rejected. My claim is not accepted on the ground that the documents.
Where is that his claim is rejected? From the order.
Lords, may kindly see. The English version is at page 94.
Yes.
Lords, but just before that, I just pointed out. I just marked it. In the Kannada version, I marked it. I just take the relevant English portion. Yes, list of documents. Lords, page 92, para 3. After examining the documents submitted by Ashwath Narayan Reddy, no documents has been submitted to prove that he is the legal heir.
No, where is the finding that
I just read it, my lords, that
after examining the documents so and so, no documents have been submitted to prove is the
Yes.
legal heir. Then further, next para.
Lords, further is about consideration of my request.
Hari Prasad and so and so.
Hari Prasad is myself.
No, they say he has not placed any documents.
Yes.
They didn't say, they have not rejected his case.
I'll make him as a party, my lords, if your lordships feels that because
No,
that's-
anyhow, I'll set aside this order and ask them to consider
Lordships.
in the lights of the order.
Lordships.
The writ petition is filed, seeing the following prayer. Then senior counsel appearing for the petitioner submits that they've issued a show cause note, issued a notice asking them to come for the inquiry on 23/7/2026, and an order, and there was an endorsement on the same day showing that the petition has not, where is that 24, the 23rd endorsement? And on 24, there was a notice for hearing dated 24/7/2026. And before that, on 23/7/2026, there is an endorsement whereby, considering the application dated 15/7/2025, it says that since a license holder has died and the license held by him has not been transferred to the legal heirs as per Rule 17A of the license, since the excise here has come into effect in the notification in reference to as a year commencing from the first day of July and ending on the 30th June of the next calendar year, and since the excise year 2025-26 has ended, it is not clear who the direct heirs of the deceased are and the legal heirs are pending the completion of Rule 17A process, and the appeal is disposed of. It is submitted that again they have received the notice of hearing on 24/7/2026. The petitions have appeared before the authorities, and thereafter an order dated
1/8/2026.
1/8/2026 is passed, whereby they have considered the case of one Hari Prasad, one Ashwadha Narayana, and the petitioner.
Hari Prasad is the petitioner.
That's what Ashwadha Narayana, petitioner, and one Ashwadha Narayana.
Yes.
And in the order, they have observed that Ashwadha Narayana has not submitted any documents and the court also observed that Hari Prasad, it is difficult to decide who are the legal heirs of the license. Therefore, the matter will cause legal confusion for the transfer of the license. An application and PNC number 606 of 2025 has been filed in the city civil court, and the judgment is pending. Since the two petitioners have filed separate petitions and documents, it is not possible to determine who the legal heirs are, and by granting the license to other persons who are not the legal heirs, it is like giving permission to sell illegal liquor. This will affect the revenue of the state. And they have referred to an order dated 3/2/2016 arising out of WP number 56185 of 2025 and 56499 to 56502 of 2015, wherein the court has observed that when there are more than one legal heir, it can only be in the joint name or in the name of one person and agreed with others. In the absence of such agreement between the legal heirs, a direction the writ petition to transfer the license to one legal heir would not be possible. Insofar as a claim as made by respondent number 4 under a will, certainly the right of respondent number 4 also cannot be adverted to in the writ petition, since it is for the competent court to decide all these aspects of the matter. Hence, the mandamus sought cannot be issued. The authority, the respondent had finally passed an order observing that the documents regarding the legal heir of the said license have not been produced. It is not possible to carry out the process of transfer of license under Rule 17A of the Karnataka Excise Rules. Therefore, it is ordered that the late Srimati Premamma V, CL9 and corresponding RVB license holder for the year 25-26, the liquor and beer stock held under CL9 and corresponding RVB license shall be taken into custody by the department and disposed of as per the rules. Then senior counsel appearing for the petitioner submits, representing the learned counsel of the petition, submits that when the petitioner has stated that there are no legal heirs to late Premamma and all other family members have no objection to transfer the license in favor of the petitioner. And when Ashwath Narayana, the other claimant, has not produced any documents, they ought to have taken an indemnity bond and ought to have transferred the license in his favor. It is submitted that already the trade license is transferred in favor of the petitioner. Generally, in all the cases that in that manner they are transferring the license. However, in this case, they are insisting for a trade succession certificate. And the senior counsel has also pointed out the earlier endorsement on 23/7/2026, notice on 24/7/2026, asking the petitioner to come for inquiry. It is submitted that they have already prejudged the matter. It is submitted that there shall be an interim, unless and until the order impugned is stayed, that would cause hardship to the petitioner. Then counsel appearing for the learned AGA on instructions submits that. No instructions.
I have instructions, my lord.
What instructions you have?
The same thing which I submitted, my lord.
That it amounts to selling of illegal liquor.
It is there in it,
That's what I'm saying. Apart from that, what are the instructions?
That is it.
The learned AGA, who is appearing on behalf of the respondent, submits that. Shall I say that you will pass an order?
No, my lords. What can be passed is direction may be given to both of them to be present again and conduct.
In the light of this ambiguity, learned AGA submits that this order may be set aside. Shall I record it?
That cannot be done. That cannot be done.
The AGA submits that as there is a dispute with regard to the dispute that who is the legal heir of Premamma, the department was not in a position to transfer the license. When once they cannot transfer the license, and they have to hand over the stocks, and that order is rightly passed, and there are no reasons to interfere with the order impugned. Next part. Having heard the senior counsel, the counsel so and so. There is a material on record. There is no dispute that there is a dispute with regard to who is the legal heir of late Premamma. According to the petitioner, he is a son of the late Premamma's.
Lords, the petitioner is the heir of the husband of Premamma.
He is the brother's son of Premamma.
Yes.
Premamma's, he is the husband's brother's son. He is the husband's brother's son of Premamma. And all other legal heirs of the brother. She is issueless. And her husband predeceased her. And all other legal heirs have no objection to transfer license in favor of the petitioner. Ashwath Narayana, who is the brother of late Premamma, it is his case that she has executed a will. In respect of that, they have filed a P&SC, and the same is.
They have not filed, my lords.
Who filed P&SC?
P&SC is, we have filed the P&SC, because
they have not filed the P&SC.
No, they have not.
They have implemented themselves.
No, in the P&SC, Ashwath Narayana is also a party. According to the Leonard, it is a submission of the senior counsel that they will only take the indemnity bond and they will not insist for the succession certificate. According to the learned AGA, when there is a dispute, they will ask for a succession certificate. Leaving all these contentions apart, the manner in which this order is passed, looking at 24/7/2026 and 23/7/2026 endorsement, notice, and later the order and order that is passed, on the face of it, it appears that there is some ambiguity in the manner in which the respondents have decided the matter. And further, when generally in all the cases, wherever there is a difficulty, when there are contesting claims by the parties with regard to transfer of license, what is the procedure that is already followed? The respondents also ought to have indicated in the order, and if so, in what cases they have done, so that there will be a clarity in the procedure they are following. In those circumstances, the court is of view that the order impugned needs to be set aside, whereby the respondents, after hearing both, the respondents already has heard both the parties, both the parties, and all the material is before the authorities. They shall pass a fresh order in accordance with law. That view of the matter, the order impugned, this court is passing the following order. The order impugned is set aside. The matter is remanded back to the, which respondent he is?
Somebody else.
The matter is remanded back to the third respondent. The third respondent shall pass orders in accordance with law within a period of 1 week from the date of receipt of the copy of the order. Copy of the order shall also be the Ashwat Narayana shall also be informed of the sits order of the court. The order shall be passed within a period of 1 week.
Your
That's 2
lordship
weeks.
said, your lordship said Ashwat Naran has filed impleading. It's not factually correct. He has not filed any impleading application.
I didn't say.
I told him that somebody else filed an impleading application, not Ashwat Naran.
Yes, I'll correct it. Yes.
Matters at 1 p.m. Cell number 73. Abhinav Anand.
My lord, one submission, my lord. Serial number 37 from yesterday it was taken to today. My compliance is on Monday, my lord. I have no other opportunity where the compensation received by me from SLAO has been directed to be deposited in court.
First call this matter. Which matter is this? Yes. Where is that?
Abhinav Anand.
I'm
Abhinav.
here, my lord. I am here.
Huh? Will come on Monday. Yes.
Lord, 57, my lord. The petitioners are owners of
Huh?
the land purchase. Serial number 57, matter is on the 10th of this month, my lord, before. Therefore, I got it posted each day, my lord, because of the rest of the work, it could not reach. If possible, after this matter, my lord, 1 minute or 2 minutes. 57.
Now the advocates thing is, even if I sit till 10 o'clock also, you're all ready to argue the matter. But I should have the patience to hear it.
That's correct. We understand the pressure of
Yes.
the court, you will ask, definitely. Lord,
My lord, serial number 34.
Hearing the matter. Yes.
for having acquired ownership as per Annex A sealed, my lord, Kata was recorded by BMP as per
This
Annex
BESCOM matter, who appears?
Bestcom, for Bestcom she appears.
I appear for the our post.
What are your instructions?
KPTCS. BESCOM for, I appear for the
Chennai Gowda,
KPTCS.
C. Chennai Gowda.
Bestcom instruction on the basis of the letter given by the BBMP, they have acted. It's a B Khata property matters. There is no plan. So that is.
That's why I wanted instructions of BBMP yesterday. You
Yes,
appear
madam.
for BBMP.
Yes, madam.
Have you initiated any proceedings for demolition of the structures?
We have issued them on 313 notice, madam.
When did you issue?
I will produce the same date. I am not aware, but my instruction is that 313 notice is issued, calling for the documents from them, and then this.
Then you don't even do anything, and what is the hurry for them to do, to disconnect the power supply and all?
It's a show cause notice, my lords. They can reply to that.
They have
till that time.
disconnected?
They have disconnected. The petition was filed on 6/7. On the afternoon of that same day, the power
And
has.
counsel for the petitioner submits that the respondent, BESCOM, has disconnected the power supply on 6th evening.
Evening.
Show cause notice was issued.
Show cause notice not issued.
Letter dated 17/6/2026 is the show cause notice.
That is, the notice was informing me to obtain NOC from BBMP. So it is not a notice to disconnect it. I
So
was
they say
directed
you
to
obtain it and you come within 1 week. That is a show cause notice.
That is the notice.
They have issued a show cause notice on 17/6/2026 and on the same, and they have disconnected the power supply on
The same day, 6/7/26, on the day of filing of the writ petition.
it is not the same day, 17/6/2026 to
Notice was issued on
7/6/2026.
17/6.
Almost 20 days later. On 7/6/2026, they have disconnected the power supply. It is submitted that the BESCOM has no authority to disconnect the power supply when there is no violation on the part of the petitioner. It is a case that they have not received any notices from the PBMP. Land Council appearing for the BESCOM submits that basing on the letter issued by the BBMP, they have issued the letter and thereafter disconnected the power supply. In the light of the order passed by, what is the judge order? In that you have that Justice Suraj Govindra's order on this. So, in the light of the order passed by a coordinate bench of this court, the respondents cannot resort to, the BESCOM cannot resort to such a procedure. And when the BBMP has not taken up any further action, the respondent shall forthwith restore the power supply. The respondent, all the respondents shall file their objections. Respondents 1 and 2, why you have made respondent 1 and 2, who takes notice? HCGP takes notice. It's already up here. 3, 4, on behalf of BESCOM and the BBMP, their objection shall be filed. Yes, next.
My lord, serial number 31 in the list, may it be repeated on Monday, because Monday there is such a stern warning from the trial court that.
Be repeated. Yes.
Matter moved at 1 p.m. Cell number 1, Kalyan Pasalraj.
For partition of decree, appeal was filed. Appeal is also confirmed. Final decree proceedings were initiated. I was implicated as respondent. Kindly go to page number 69. Compromise. Final decree proceedings. Though I was implicated as respondent 5, my lord, a compromise petition was filed in exclusion of me, and they have compromised the matter. The learned judge at page number 17, my lord. Kindly go to page number 17.
What is the suit for?
Suit for partition.
Preliminary decree is passed.
Final decree.
In the final decree?
The final decree proceedings were initiated. Some of the parties to the final decree appears to have settled the matter. Accordingly, an application under R23 Rule 3 was filed. I was not a party. On the date of the suit, I was a minor. On the date when the FDP was initiated, I had attained majority. Though I was implicated as the party as respondent number 5. In exclusion of me, they filed an application under R23 Rule 3. At page number 17, my lord, the learned judge dispenses notice to me. Kindly go to page number 80. I'm sorry.
The question of dispensing the notice under in a compromise petition.
Kindly page number. That is what the finding of the learned judgment.
Where is that?
Page number 80.
You are represented by whom?
No, there was no notice at all to me.
No, before when you were minor, you
My
must
mother.
have been represented.
Grandmother.
Grandmother was a party to the
Yes.
compromise.
Yes, no. Kindly go to page number 80, minute.
Yes.
Petitioner and respondent number 1 to 4 present along with their counsels and furnished copy of Aadhaar card. Advocate for petitioner filed IA to discharge the minor guardian to respond for the 5. Peruse the copy of the birth certificate respondent 5. Since respondent number 5 has attained majority, the guardian to respondent number 5 is hereby discharged. The advocate for petitioner and respondent number 1 to 4 jointly filed IA and R23 Rule 3 PC. Respondent number 5 is absent, but has not filed any objections to the commission's report. Hence, the presence of respondent 5 is dispensed. The terms of the compromise petition was read over and explained to the parties hearing, to which they have consent.
Signed on behalf of grandmother is not signed.
No.
Which court is this?
Senior Civil Judge, Bengaluru Rural District. On the basis of this compromise decree, it is engrossed on the stamp paper also. Now they are threatening my possession. They have come with the bulldozers and tried to remove me from the.
No, you are questioning a compromise decree.
Is it not?
questioning a compromise decree.
I have questioned it before the trial court. I have made an application under since
No, what are you questioning before this court?
I have questioned the trial court ought to have stayed the compromise. On the contrary, ordered to issue notice to the parties returnable by 24.
Where is that?
Page 17. Annexure B. Annexure B is the petition made. Order. Annexure
Petitioner,
C.
no representation.
Yes. Without notice, how could I be represented?
Please come. The petitioner is before this court. Agreed with the, where the court has refused to stay the operation of the compromise decree dated 16/7/2026. It is a case that without the petitioner's presence, without the petitioner being a party to the compromise decree, a compromise decree is passed by the court, and by virtue of that, now the petitioner is and they are taking steps to dispossess the petitioner. This court has, and the learned counsel of the petitioner has also drawn the attention of the court to the order dated 2/4/2026, where it shows that the petitioner is not a party. Considering the same, there shall be stay of all further proceedings pursuant to the order dated 16/7/2026.
May I request for hand delivery, my lord?
Bill number 2.
Threat of disposition.
Memo.
Yes.
Number 2,
Memo.
Nishan, GK.
There's a caveat filed by the other side, my lords.
You have to serve papers.
I've
on-
served him on online, my lords. He said he's out of station, my lords. May I request the matter be taken up on Monday, my lords?
Monday.
My lords, there's one threat, my lords, from the bank. Can I get some protection? Please. my lords.
My lord, please, serial number 37, please, my lord. It was taken up from yesterday to today. The reason being that on Monday it is for compliance. I'm required to deposit rupees 7 crore 50 lakhs. The caveator was there yesterday, but still
Where is the caveator now?
yesterday they took a date, my lord, but today they have not even come to court. Since morning I've been here, my lord.
Have you called him?
My lord, I not receiving or it's going automatically to reject.
No, not reject. Don't say so. Makes statements. Sunil Rao's number at least.
Sheshgiri Rao, respondent.
It can be taken up on Tuesday or Wednesday. Let the order be kept in abeyance only till then, my lords. I'll undertake that I'll argue the matter without insisting for an extension. Because I
What
should
is
not.
going to happen on Monday?
Lords, Monday it is kept down for contempt, my lords. They should not strike down my pleadings. Because
I'll
for
take it up on
non-compliance,
this matter on the top of the list on Monday.
lordships.
I made a mention yesterday, my lord, that I'll keep my party present. My learned friend is here, my lord. He's here, my lord. If my lords have no time, I can come back on Monday also only to give that undertaking. Monday, whatever.
Let them file an update, my lord.
No, no, I'm.
Yes, my lord. Let them file. But on the matter has been posted on 13th. Because they have to pay. my lord.
13th is,
Matter
Monday
set
is
out-
not 13th. Monday is not 13th.
No, no, my lord. Matter has been set out on 13th. My lord, let them pay, my lord, 50% of the amount by 13th, my lord. Remaining amount, my lord, let them fix a date timing, my lord. They have to pay 2 crore 40 lakhs as on today, my lord.
Yesterday, you have said that it is, if they file a affidavit, that's more than enough undertaking. I said, if they fail to do so, I'll say that it will be, could they have to pay costs of 10 lakhs?
Yes, ma'am. We will take it on Monday.
Monday.
Monday, my lord.
That is, all matters will come on Monday.
Of course, my lord. I
Don't
just
have
wanted to, no, I just wanted to make a
Number
mention.
57, your lordship. 57, your lordship.
Serial number
Matter is set on for
34.
See,
matter is set on for arguments, my lord, on tomorrow. It was posted actually for 1st of this month. I requested the court, the matter is coming up, therefore taken up.
but the court will hear the entire
understand.
matter on Monday itself.
No, no, my lord. I requested the time for long time, my lord, because there is a rush in the court, your lordship. However, trial court granted time till 10th, your lordship. Otherwise, I would not have, my lord, pressed the matter, my lord. That is the only difficulty. I asked for more time, your lordship, because of the rush in the court.
Yes.
Well, the petitioner filed a partition suit, Your Lordship. And my lord, the original plaintiff, my lord, died, my lord. Then, my lord, subsequently, my lord, IA number 22 and 23, my lord, came to be filed for reopening and for chief examination of the party, Your Lordship. That came to be rejected, Your Lordship, on the ground that earlier I had given one chance to you, therefore you are not made use of that.
Where is that?
Order, my lord, kindly see, para 10, Your Lordship. Cost was imposed, therefore, on para 10, my lord, page 79, my lord. On 22/9/2025, plaintiff has filed IA number 1718.
How many times you will file the application?
That's why, madam, it is a mistake of the, once the argument was, in fact, cross-examination was concluded, Your Lordship. In the meantime, original plaintiff died, Your Lordship. Then, my lord, two documents were found by the.
He died, when he died?
My lord,
When he died?
my lord, when it is not disclosed, my lord, here, my lord. That's the reason.
There is, how can?
Cost
how
was
can-
imposed, my
this
lord,
is-
no doubt, my lord,
this-
cost was
that's
imposed.
what 22/9/2025.
Twice cost was imposed, my lord. And two documents were traced now, my lord. Therefore, I have stated so in my affidavit, Your Lordship.
Keep on tracing the
No, my lord.
documents.
Any day fixed, my lord, I will go complete my.
Why should the court show lenience to your client?
Because, my lord, only two documents
Let's
were
see,
found, Your Lordship.
what did you say in your affidavit?
Affidavit, Your Lordship. I would like to.
Will
Let's-
not entertain these kind
No,
of petitions.
para 2, my lord. Para 2, page 66, Your Lordship.
What
This is
did
the
you- what
only
did you
reason,
say?
Your Lordship. If Your Lordship satisfied, my lord, Your Lordship may. I further submit that on 5/11/2025, I have filed 3 IAs for reopening of the above cross-examination of DW1 along with IA under Order 7 Rule 14 along with the document. And in this regard, the defendant have objections to this said application. And after hearing the same, Honorable Court was pleased to allow the said applications on cost on 7/2/2026. I further submit that at the time of cross-examination of DW1, some of the documents which has been produced by the legal representatives of the plaintiffs has been confronted to the witness, but the witness has admitted some of the documents and regarding other documents like the statement given by the first.
You are referring to this.
This is the only reason, Your Lordship.
No, you are referring to 5/11/2025.
Yes, Your Lordship.
Before that 22/9/2025, you don't say anything.
That's correct, Your Lordship.
How many times? IA number 17
No,
and
it is
18.
always,
IA number 19
it
to
is on the
21.
record, Your Lordship. I have stated so in my petition, my lord. In my petition, how many times time was granted to me?
Only once you stated on 5/11/2025.
No, here affidavit, my lord, they should have stated, Your Lord. But in my writ petition, I have stated exactly, my lord. All the times which has been granted by the court, I have not suppressed anything. I have stated so before this honorable court, my lord. How many times court was granted? How many times cost was imposed?
No, why should we grant? That I'm not able to understand.
In the interest of justice, my lord,
justice. It will go
because
on. It will
the
go on
LRs
like
of the original plaintiff came on record, Your Lordship, and then, my lord, they filed, my lord, knew of the.
If the court grants it now, he will come up with another 10 applications.
No, my lord.
No. That's
Yeah,
the practice.
any time, my lord, fixed, my lord, on that day I will complete.
I will allow it, if you ask your client, I'll allow it on 20,000 costs.
That they are bound to pay, Your Lordship, because it is our mistake, Your Lordship. They will,
Where
we
is
will.
it? Who appears for the respondent?
The K-waiter is there, Your Lordship, but they are not, I have served the copy long back, Your Lordship. K-waiter is.
But he doesn't know that the matter will be taken up now at out of turn at 1:50.
No, even yesterday, day before yesterday also, my lord.
So he must be there now
His
for
name-
passing the order.
At least interim order, Monday, my lord, till then, my lord. So that I will bring him on Monday, my lord.
Also, second matter. On
Yes, Your
Monday's
Lord.
list.
Serial number 34, my lords. This matter may be tagged along, which is to be listed on 10th. That is WP 235.
Just along with so and so.
Serial number 65, my lord. That will be taken up on Wednesday.
65 Wednesday.
Much of it.
Serial number 47, my lord. Yesterday, the matter was listed, my lord. Because of time given by the respondent, the matter was listed today, my lord. The day by day, the proceedings are going on the lower court.
So
That is
come
6th
up on Monday.
Monday, much of it.
Come on Monday. All matters will come. Don't mention for that.
My lord, may I make one submission, my lord? It take 2 minutes. My lord, if the lordship can recollect, there are certain matters which pertains to tripartite agreements which are part heard before this honorable court. Out of it, 4 matters were dealing only for the purpose of paper publication, my lord. Now that is being posted before a different bench. So I have filed a memo in the morning. I could not explain it because of the paucity of time. I made that mention over there. I have made that mention before the bench, my lord, but the classification has been changed. It is coming as, instead of GMRES, it is coming as DRT. So that is the reason I'm making the submission to connect with the pending matters, my lord. Can I can I file a memo for listing it before this judge, this honorable court, my lord, stating the reason? Before this honorable court, I'll file a memo for listing. I'll file the necessary application there, my lord. Much obliged.
Court officer, madam, Madhyana sitting
No, 47. 47.
Court officer ma'am, Madhyana sitting ilma ma'am.
All matters so in the fresh matters will be repeated on Monday. All fresh matters in list number
Okay.
1 will be repeated on Monday.
List 2
Okay,
ma'am.
madam. Thank you, madam. Thank
List 2 will be adjourned. Wherever urgency is there, I will.
Thank you ma'am, thank you.
ಮ್ಯಾಮ್ ಒಂದ್ಸತಿ ಇನ್ನೊಂದ್ಸತಿ ಲೌಡ್ ಆಗಿ ಹೇಳ್ತೀರಾ ಮ್ಯಾಮ್ ಎಲ್ಲ ಕಡೆಗೆ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮ್ಯಾಮ್ ಇನ್ನೊಂದ್ಸತಿ
That list number 1 fresh matters will be repeated on Monday. Wherever interim orders already granted by our court, such matters will be date assigned. And in list number 2 matters, except extreme urgency pleaded matters, all matters will be adjourned to September 1st week. Wherever interim orders are there, that will be extended if it is in existence till today.
ಓಕೆ ಮ್ಯಾಮ್ ಥ್ಯಾಂಕ್ ಯು ಸೋ ಮಚ್
you, madam. Thank you. Thank you, madam.
Thank you ma'am, thank you.
Madam, order.
Court officer.
ಸರ್ ಹೇಳಿ.
ಸರ್ ಸಿಟ್ಟಿಂಗ್ ಇದೆಯಲ್ವಾ?
ಇಲ್ಲ ಮಧ್ಯಾಹ್ನ ಮೇಲೆ ಇಲ್ಲ ಮೇಡಮ್.
ಇಲ್ವಾ?
ಇಲ್ಲ ಇಲ್ಲ.
ಸರ್ ಲಿಸ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ 6 ಏನ್ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಸರ್?
ಇಷ್ಟು ಸೀರಿಯಲ್ ನಂಬರ್
6 ಸರ್, CRP 842/25.
6
6 ಸರ್, ಲಿಸ್ಟ್ 2.
ಇಷ್ಟು 6 CRP 842.
ಕರೆಕ್ಟ್ ಸರ್. ತಾಹಿರ್ ಅಡ್ವೊಕೇಟ್ ನೇಮು. ಸರ್ ಡೇಟ್
ಮೊಹಮ್ಮದ್ ತಾಹಿರ್ 24/8.
24/8 ಸರ್? ಸರಿ ಸರ್, ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 35 ಡೇಟ್ ಹೇಳ್ತೀರಾ?
35 ಲಿಸ್ಟ್ ನಂಬರ್?
ಲಿಸ್ಟ್ ನಂಬರ್ 1.
35 ಎಲ್ಲ ಮಂಡೆಗೆ ಪ್ರೆಸ್ ಮ್ಯಾನ್ರ್ ಎಲ್ಲ ಮಂಡೆಗೆ ರಿಪೀಟ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದಾರೆ ಮೇಡಮ್.
ಸರಿ. ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು ಸರ್.
Fifty-nine 11/8.
ಸೋಮವಾರ ಅದು ಒಂದ್ ಮ್ಯಾಟರ್ ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದಾರೆ. ಸೀರಿಯಲ್ ನಂಬರ್ 37
10/8 top of the list.
10/8. ಸರ್ ಲಿಸ್ಟ್ 2 ಕೊಟ್ಟಿಲ್ವಾ ಇನ್ನು? ಲಿಸ್ಟ್ 2 ನಲ್ಲಿ 24. ಸರಿ.
ಯಾವ ತಗೊಂಡಿದ್ರು ಬೆಳಿಗ್ಗೆ ನಾವು ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಹೇಳ್ಬೇಕು ಇಂಥ ಕಡೆ ಜನರಲ್ ಆಗಿ ಕೊಡಕ್ಕೆ ನಾವು ಕೋಟಾಕ್ಸ್ ಕಳಿಸೋದು ಹೇಳಕ್ ಹೇಳಿ ಕಳಿಸೋದು. ಬೆಳಿಗ್ಗೆ ಕೊಡಕ್ ಬಂದಿರಂತೆ ನಿಮ್ಗೆ ಗೊತ್ತಾಗುತ್ತೆ. ಸ್ಕೂಟಿ ಹೋಗಿ ಅಲ್ಲಿ ಸ್ಟೋನಾ ಅವರು ನಾವು ಸ್ಕೂಟಿ ಕಳ್ಸೋದು ಅಂತ ಅವ್ರ ವಕೀಲರನ್ನ ನಾನು ಜನರಲ್ ಆಗಿ ಕೊಡಕ್ ಅಂತ ನಮ್ಗೆ ಹೆಂಗ್ ಗೊತ್ತಾಗುತ್ತೆ? ಸ್ಕೂಟಿ ಹೋಗಿ ಅಂತ ಹೇಳಿರ್ತೀವಿ. ನಿಮ್ದು 25/8 ಎಷ್ಟು ಸೀರಿಯಲ್ ನಿಮ್ದು? 5 ನೋಡ್ತಾ ಇರೋದು ರುಕ್ಮಿಣಿ ಪಾರ್ಟಿ ನೇಮ್. ನಾನು ಅಡ್ವೊಕೇಟ್ ಇಂದ ಸೇರ್ತಾ ಇದ್ದೀನಿ. ಸಾಮಾನ್ಯ ನಾವು ಅಡ್ವೊಕೇಟ್ ಅಷ್ಟೇ. 25/8 25/8 Hello? ಹೇಳಿ ಸರ್. ನಾವು ಫ್ರೆಶ್ ಮಾಡಿದ್ರೆ ನಾವು ಮೇಡಮ್ ತಗೊಳ್ತಾ ಇಲ್ಲ. ಕಾಂಪ್ಲೇಂಟ್ಸ್ ಆದ್ರೆ ಎಷ್ಟು ದಿನ ಹೇಳ್ತಾರೆ. ನಾನು ಜನರಲ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಕೊಟ್ಟಿದ್ದೀವಿ ಅವರು ನೀವು ಪೆಂಡಿಂಗ್ ಅಲ್ವಾ ನಿಮ್ಮದು? ಸ್ಕೂಟ್ನಿಗೆ ಯಾಕೆ ಹೋದ್ರೆ ಇವರು? ಹಾಂ ಬೆಳಿಗ್ಗೆ ಮಾರ್ನಿಂಗ್ ಇವಾಗ ತಂದಿದ್ರಂತಲ್ಲ ಮೇಡಮ್? ಇವಾಗ ಅಂತವ್ರೆ ಕಳ್ಸ ಕೇಳಿ ಅದಿನ ಸಾಮಾನು ಕಳ್ಸ ಕೇಳಿ.
ಡೇಟ್ಸ್ ನ ಕೊಟ್ಟಿಲ್ವಾ ಲಿಸ್ಟ್ ಟು ಸೀರಿಯಲ್ ನಂಬರ್ 10 18 ಹಾ ಹೌದು ಇನ್ನೊಂದು 18 ಹಾ 31 8 ಇನ್ನೊಂದು
ಏನ್ ಮಾಡಿಲ್ಲ ನೀವು ಕೆಲಸ ಮಾಡಿ ಒಂದು ಕೇಸ್ ಬಗ್ಗೆ ಮಾತಾಡೋಣ ಆಗಲ್ಲ ರಿಪೋರ್ಟ್ ಮಾಡ್ತೀನಿ ನೀವು ಕೆಲಸ ಮಾಡಿ ನೀವು ಬರ್ಬೇಕಾಗುತ್ತೆ ಸೋಮವಾರ ಹೌದು ಆಯ್ತು ಬನ್ನಿ ಓಕೆ ಸಾಹೇಬ್ರ ನಾನು ಮಾಡ್ತೀನಿ ಸರ್ ಡೆಫಿನೆಟ್ಲಿ ಅವ್ರದ್ದು ಆಮೇಲೆ ಹೇಳ್ತೀನಿ ಕೊಡಿ ಹೇಳ್ತೀನಿ ಸರ್ ಲೀಸ್ಟು ಸೀರಿಯಲ್ ನಂಬರ್ 3 ಸುಮ್ಮನೆ ನೀನೇ ಕೊಟ್ರೆ ಡೇಟು ಏನ್ ಸರ್ ಡೇ ಬೈ ಡೇ ಹ್ಯಾಂಗ್ ಸರ್ ಇದು ಅಲ್ಲಲ್ಲ ಸೆಕೆಂಡ್ ಲಿಸ್ಟೇ ಬರ್ತದ್ದು ಸೆಕೆಂಡ್ ಲಿಸ್ಟೇ
26 ಪೀಕೆ ಏನು ಹೋಗ್ಬೇಕಾ?
ಮೇಡಮ್ ನಮಸ್ಕಾರ ಮೇಡಮ್. ನಿನ್ನೆ ಒಂದು ಹೈವೇ ಸ್ಟೇಷನ್ ಆಗ್ಬೇಕು ಅಂತ ಚೀಟಿ ಬರ್ಕೊಟ್ಟು ಹೋಗಿದ್ವಿ ಮೇಡಮ್. ಒಂದು 3ನೇ ತಾರೀಕು ಒಂದು ಮ್ಯಾಟ್ರ್ ಬಂದಿತ್ತು. ಮ್ಯಾಟ್ರ್ ರೀಚ್ ಆಗಲಿಲ್ಲ. ಅಲ್ಲ 437242 ಮೇಡಮ್ ಎಂಟ್ರಿ ಮಾಡೋದಿತ್ತು. ಮೇಡಮ್ 31ಗೆ ಮ್ಯಾಟ್ರ್ ಬಂದಿತ್ತು. 31st ಜುಲೈಗೆ. ಮತ್ತೆ 3ನೇ ತಾರೀಕು ಹಾಕು. 3ನೇ ತಾರೀಕು 2:30ಗೆ 2:30ಗೆ ಮ್ಯಾಟ್ರ್ ರೀಚ್ ಆಗಿದೆ.
ಏನ್ ನಂಬರ್ ಅದು? ಒಂದ್ ನಿಮಿಷ.
ನಿಮ್ಗೆ ಬಂದು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿ.
ಒಂದ್ ನಿಮಿಷ ಹೇಳಿ. ಏನ್ ನಂಬರ್ ಅದು? ಪೆಂಡಿಂಗ್ ಅಲ್ಲಿ ಇದೆಯಾ?
2374.
ಇಂಟರ್ನೆಟ್ ಅಲ್ಲಿ ಇದೆಯಾ? ಎಂಟ್ರಿ ಮಾಡ್ರು. ಒಂದ್ ನಿಮಿಷ. ಗೊತ್ತಾಯ್ತು. ಅಲ್ಲ ದಿವ್ಯಾ, ಇದೊಂದು ವಿದ್ಯಾ 23742 ಆಫ್ 2026 ಅದೊಂದು ಫೈಲ್ ನಾವು ಕೇಸ್ ಹಾಕ್ತಂದು ತಗೊಂಡು ಕೋರ್ಟ್ 19 ಅಂತ ಹೇಳ ಅದು ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗ್ತಿಲ್ಲಂತೆ. ಇಲ್ಲಿ ಕೋರ್ಟ್ ಆಗಿ ಇವತ್ತು ತಗೊಂಬನ್ನಿ, ಹಂಗಿದ್ರೆ ಅದು ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿಸ್ಕೊಡ್ತೀನಿ. ಮುಗ್ದಿದೆ ಸರ್. ಏನ್ ಬೇಕಿತ್ತು ಹೇಳಿ? ಯಾವ್ದದು? 51 ನಾಳೆಗೆ ಬಿಟ್ಟಿರ್ಬೇಕು ನೋಡಿ ಸರ್. ಮಂಡೇ ಅರ್ಜೆನ್ಸಿ ಪ್ಲೀಡೆಡ್ ಮ್ಯಾಟರ್ ಲಿಸ್ಟ್ ಬಂದಲ್ಲಿ ಇದ್ದೀರಲ್ಲ, ಮಂಡೇ. ಹಾ ಕೊಡಿ ಸರ್, ಆಯ್ತಾ?